Hey, good morning. I'd like to welcome everyone out to our law and licensing meeting. And again, just for those listening online, we apologize. There was just a slight technical issue, and our IT team addressed it expeditiously, and we're good to go. Let's do a roll call vote. And Board Member Longacre, Board Member Bollinger, Carol Lear, Board Member Lear. Oh. Carol's patient, so I'm sure this isn't bothering her at all. And Board Member Hall. So we do see Carol Lear. We see Board Member Lear online. So she is present. Board Member Hall, not present. Oh, as if on cue. Thank you, Board Member Hall. So that is 100% attendance following a late night board meeting on Thursday. So I want to thank everyone for coming in and being in a good disposition. We have a full agenda. Let's start with public comment, and I have Felix Espinoza. And Felix, I believe you spoke yesterday at our board meeting. So at committee, we're a little bit more lax with the time. I think they gave you, is it 3 minutes of public, 2 minutes? We'll give you 2 minutes and 10 seconds. No, we will. So generally, it's at the chair's discretion. I'm just going to mark the clock for 4 minutes. And then at the 4 minute mark, I'll just let you know. Okay. I do have
There you go. Okay, thank you. I do have handouts similarly from yesterday as well. I appreciate it. All right. Good morning. My name is Felix Espinoza, founder and chairman of Utah for Rational Sex Offense Laws. Yesterday, I addressed the escalation concern regarding item 10.2 from administrative rulemaking to a statutory amendment of 53-29-306. This morning, I want to name a specific statutory conflict the proposal creates that falls directly within this committee's jurisdiction. The proposal's activity-based expansions covering school-sponsored activities of school grounds do not address their collision with 53-29-307, the statute governing a registrant's presence with the child. This statute contains an explicit natural child exception. A registrant may accompany their own child without prior written authorization. The legislator included that exception deliberately. Under the proposal as drafted, a registrant parent attending their own child's school field trip, school play, or graduation activities 53-29-307 currently permits could be prohibited by the new activity-based expansion. That is not a registrant advocacy argument. That is a parental rights argument, a family stability argument, a constitutional due process argument. The form safeguards section addresses this with a single line. No unintended consequences for specific geographic areas or student populations. It says nothing about registrant parents and their own children. Here's why that matters at scale. Utah has approximately 7,250 registrants living in the community. In 16 months, 27 of the 230 registrants who reached out to Utah for housing assistance were families with children. Extrapolated conservatively, that represents a lower bound estimate of 850 registrant families with children currently living in Utah communities. These are not hypothetical people. They are parents with children in Utah public schools that this board serves. This proposal would prohibit all registrant parents from attending their own child's school events because the activity-based expansion does not account for the statute it displaces. USBE asks this committee to return the request to staff for an explicit statutory coordination analysis addressing the parental rights conflict identified here before any transmission occurs. Thank you.
Mr. Espinoza, thank you for the public comment.
Certainly. Thank you.
The next item on the agenda is item 2.2, amendment to master data sharing agreement with Utah Education Policy Center. And Director Rasmussen, it's my understanding you're going to cue that up for us? Okay. Oh.
Thanks for your patience with me as I learn how to participate in this meeting. I am Student Data Privacy Specialist Nicole Sanchez. I'm filling in for Katie Chalice today, as she's not able to be here. The item up is the Master Data Sharing Agreement between USBE and the Utah Education Policy Center. And the amendment that we're considering is just a one-year extension of that agreement. We do have Andrea Rohr here from UEPC to answer any questions that anyone might have. And I will also do my best to answer any questions that you might have.
Any questions?
If I may, Chair.
Yeah, please, Vice Chair.
Just a clarification. I know that when Director Chalice kind of front-loaded us, some of us, and I just want to make sure the public understands. So the purpose of the extension is to then provide the time and resources needed to revisit the agreement between the two entities. Is that fair statement?
Yes, that's correct.
Thank you.
You know, if Director Rohr is here, I do have a couple questions, if that's possible. And I apologize in advance. I was looking up for the email that I sent you, and I see it's in my outbox. So it's a really good email, but Director Rohr, I had posed 3 questions. We discussed data privacy yesterday in our board meeting, and these are going to hit along those same lines, but please, for the record, if you could just state your name and your position, and then we'll start.
Certainly. I'm Andrea Rohr. I'm the director of the Utah Education Policy Center at the University of Utah.
And my first question goes to that. So at the University of Utah, it's my understanding that student data privacy, if you're a state organization, your data has to be housed in the United States.
Correct.
And does the University of Utah also, are they legally required to house all of their student data in the United States?
I can't speak to, yes. However, I would say that someone at the University of Utah could speak for the University of Utah writ large. However, with regard to the data that we collect, so the Utah Education Policy Center often collects data as a primary source, in addition to any data that's shared through our MDSA, is unequivocally housed within the United States.
And my other question was, and I was just given these yesterday, and I thought I was going to look at them when I got home, but
I hear it was a late night.
yeah. So is there an exception to that requirement?
Not for us, no. The maintenance of our servers and all of our data, we've stipulated that. One, it's best practice for us, but it's also part of our MDSA.
And the data that you are being shared from USBE, it's my understanding that that data would also be required to be housed here in the United States.
Correct.
Okay.
Yes, absolutely.
Okay. I have no further questions. Any questions from any other committee members? Board Member Longacre?
Yeah, so I'm looking at this master data sharing agreement, and it looks like the last time it was signed, it was back in 2018. And for this, the standards back in 2018 are probably a lot different than the standards today. But I was reassured that if anything happens while we're waiting this year for it to be updated, we fall back on the current law. So we're still
Correct.
covered.
Yes,
Okay.
thank you for that point. There should be an amendment in there from about 2021 because we do them every 5 years since 2010, which is the first one that we entered into. And okay, good, 21. Okay. And so what we provide our assurances as well, working with the Data Privacy Division. So we monitor and communicate in an advisory capacity with the Data Privacy Division, including Katie Chalice, for example, to understand each year whatever laws federally or at the state and or rules that are changing, and then we adhere to that as well. So even, you're correct, even if it's not part of the last written amendment, data privacy, our comment is it's our Fabergé egg, and it's something that everyone within the center and the university takes great pride in protecting because of the vulnerabilities it can create. So everything from how we collect it, how it's moved from USBE, to how we use it adheres to all of those laws, rules, and standards.
I don't see any other lights. If there are no further questions, we're ready for a motion. We're almost ready for a motion. As soon as it pops up on the screen, we'll be, oh, that screen. Thank you, Vanessa.
Okay, Chair, I'm happy to make a motion.
Thank you. Oh,
Hey.
Vice Chair, once, this is my apology. Board Member Lear, are you able to hear the committee?
Yes.
Okay.
Can you hear me?
Yes. And
Yeah, I can hear perfectly.
okay. And I didn't check to see if your hand was up or if you had any questions.
I don't. Thank you.
Okay. Thank you, Vice Chair.
Okay, thank you. With that, I'd like to make a motion that the committee approve the second amendment to the Master Data Sharing Agreement with the Utah Education Policy Center, USBE 210089MA, Amendment 2 and 4 to the board for approval.
So the motion before the committee is that the committee approve the second amendment, the Master Data Sharing Agreement with the Utah Education Policy Center, USBE 210089MA, Amendment 2, and forward to the board for approval. All those in favor? Any opposed? Okay, that motion passes unanimously. Thank you.
Thank you.
Thank you. So we do have a matter listed for a time certain at 9 o'clock, and that is with the Assistant Attorney General, Laura Cooper, and possibly Darren Goff. Even though I believe that the next matter, 2.4, will take longer than the 15 minutes we have before 9 o'clock, if there's no objection by the committee, I would suggest that we start with item 2.4. Not seeing any objection. Director Rasmussen, do you want to cue that up for us? Thank you.
Sure. And, if we can invite Lisa McLaughlin to come up too. Essentially what we have here is Alcott Learning has applied to be in an educator prep program. Staff reviewed this and had some concerns with approving this program based on the definition of an educator preparation program under our rule. I'll just show you that just briefly to show you what the concern was. Specifically in the definition section, it lists here under 5B, an educator preparation program may include a program developed by or associated with an institution of higher education, individual LEA, consortium of LEAs, or the board. There is some flexibility in this rule, but as we understand, Alcott Learning is a private for-profit business, and it is not really similar to any of the types of entities described in the rule. And so because of that, staff denied the application and has encouraged Alcott Learning to appeal to the board if they feel they should be treated differently than what staff has concluded. Lisa, do you have anything to add to that background?
I would add that there were two concerns. One was the definition of educator preparation programs, and the other one was around clinical experiences, where the application that they have submitted said that they would like to offer clinical experiences in non-traditional or out-of-state placements. And we've talked a little bit about that. Weren't sure if that met the definition in the rule around clinical experiences need to be completed in a P12 classroom setting, because we don't necessarily have a definition of what that is. So that was another area of concern that we'd like the board to explore. Thanks.
Thank you. And before turning the time over to have you introduce the individual sitting to your left, let me just say that I know Liz Quist. She is adjunct faculty at Ensign College. I have no direct managerial or other professional oversight or relationship with her, but I just wanted to put that on the record. If you don't mind introducing them, and we'll go from there.
Thank you. So I'm Lisa McLaughlin. I'm the Educator Preparation Coordinator here at the Utah State Board of Education. And I think I'm going to let them introduce themselves because they probably will do a better job than I will. So.
Okay, thank you so much for having us here today. First of all, we just wanted to thank Lisa and Dr. Height and the great staff at USBE. We have spent a lot of time with them over this, and we really appreciate their professionalism and the support, and also just the feeling we've had along the way that we're all here to support students, and so that's been great. I wanted to share a little bit about. Oh, I'm sorry. My apologies.
And I am Josh Black, and I'm grateful for the staff as well and the great experience that we've had integrating their guidance into our proposal and solving problems with them over the past several months. Glad to be here. Thank you.
Thanks. So just to introduce a little bit about what we're doing. So I've been in education and education reform for over 20 years. And a big issue on my mind, I think 17 years ago, I met with the first university to talk about how can we do more for a teacher to bring great candidates into the classroom. I've met with Harvard and BYU and John Adams College and different, trying to kind of crack this. And I've just been amazed with the competency-based framework that has been created in Utah. So unique, I think the best in the nation. And I use that as an executive director and co-founder of Williamsburg Learning here in Utah, Leadership Academy Utah and Williamsburg Academy, which I led for 7 years. And I created all kinds of weekly trainings, retreats, career advancement programs for my staff, and led those as well. And as I did that, I found that my staff, I needed to train them in certain ways that were different than what they were receiving in traditional programs. And as I did that and then found more about the Utah Competency Framework, I went through the competencies like, these are exactly the things that we need to be training teachers on, and saw a great opportunity to really help get great candidates in the classroom. So I remember one of the candidates I had, she was an award-winning youth Simon & Schuster author, and she wanted to teach 8th grade, and I couldn't get her into the classroom. And I thought, we would be so lucky to have her teaching 8th graders, and yet there's not a path. And then things changed in Utah, and it's been amazing to see that. So since we started on our proposal, I've met with many schools, including Hanifi Oguz and Ram Prasad Bopana at Beehive Science and Technology Academy, Carolyn Charette and Jen Wallstead at American Prep Academy, Kim Frank, founder of the first charter school in Utah, the John Hancock School, and the executive director of the Utah Charter Network, Kim Goetz, superintendent of the Canyon Grove Academy Schools, and Heidi Long, executive director of Ignite Entrepreneurship Academy. All of these directors have expressed deep, enthusiastic interest in what we're doing. They have shared a willingness to place teachers in our program as soon as we are ready to move forward, if we're able to do that, and to send candidates to our pilot program as well. So on Monday, I spoke at the Utah Charter Network annual symposium. There were about 350 participants, and I shared about our potential Apple program and said we are pending USBE approval. It was overwhelmingly positive. We had 10 school directors reach out to us. We had a Utah official with a doctorate in education, but no license, said, I would love to be one of your first customers when the time comes. So we're also currently working to become possibly the official licensure partner with the Utah Charter Network and possibly the new Charter School Resource Center. So we're seeing a strong need. But also in the districts, we've reached out to 15 superintendents. I'm meeting with Christine Fitzgerald of the San Juan School District next week to discuss the licensure needs of Blanding, Monticello, and Monument Valley and the issues that they're dealing with out there. We would love to help all teachers from my network is charter schools, and we've just had a big response from them, but we're so willing to help anyone in need, and we feel like we could really help rural schools as well. One of the courses we hope to create is a course where we support people in their clinicals, an apprenticeship course, and we would like to share with them incentives we know that in some districts you have 150 applicants for one job, but in others there are very few. And we would love to say, hey, here's an incentive to go out to Mexican Hat and to teach out there for a little while. So we feel like we will be unique in that sense, but we do not feel like we are unique actually in the sense of being a whole new type of EPP. So we know of several Apple programs, including the Teacher Development Services program that is a for-profit program with no school attached. And what they do, they consider themselves consultants, and that's what it says on their website, and they help rehabilitation centers to have trained teachers. And I think in many ways, we are not, blazing a fully new trail. They've been doing this for a while. We also have independent, it is the Teacher Development Services, and there's also the Uinta RTC LLC as well. And of course, private schools that are some of which are for-profit as well. So really, we believe there is such a clear need here, and we're getting that response. We are so willing to work with the staff on deprioritizing or changing things that aren't working, or possibly we've tried to integrate all the feedback we've received. And it sounds like we've missed a couple of things, but we would be so open to making changes there. But we do believe that within board rule, where it says in several places, which we're happy to dig into if it would be helpful, but we do believe we fully meet the EPP definition, and that there is precedent for what we're doing. So, thank you so much.
Thank you, Ms. Quist. Any questions from the committee? I have some, but I'll hold them off till the end or a later time. And Carol, Board Member Lear, I am looking at your larger-than-life image. So if you have a question, you can just hit the yellow hand or the white hand, or just let me know verbally. So Vice Chair Bollinger.
Yeah, thank you. I actually do have several questions. I appreciate you being here to answer questions, and this is something that we've even actually individually talked to. Licensing is something that this board has been focusing on to make sure that we strengthen our licensing to help take away the red tape. I myself, I will say, I'm a product of an alternative pathway. So my senior year of college, I decided I want to be a teacher. Then I did an alternative pathway through Utah State. I taught and went to school at night. So I support options for teachers. My first question is, you said you feel like you meet the requirements. So it says, and if I understand, Director Rasmussen, so it says an LEA or appear to have an association with an LEA or a consortium of LEA boards in the rule specifically. Tell me how you meet that criteria.
Thank you very much. I think the first and most important example would be that there are other entities that are already approved and operating currently. And the Teacher Development Services that was mentioned, for-profit LLC, we cannot find any material differences between our business model and their business model. They've been approved since 2022, and there are several others that have been approved. All were approved under the same wording, even though they were approved under older versions of the rule. And so the most compelling evidence that the word may is not restrictive to the terms that follow it are simply the fact that we have already many approved Apple programs that do not fit that, including private schools and all the LLCs and things that are in the list that are currently operating.
Okay, thank you. Dr. Height, can you help us understand? So this teacher development services, is that in the state of Utah? And is that for K-12 schools, or is that for other alternative services?
Thank you. Malia Height, Executive Coordinator of Educator Licensing. They are within the state of Utah, and they're working with regional treatment centers that are approved and supervised by USBE Special Education. So they're providing special education services to their Utah students within the state of Utah.
So would they fall into the realm of providing public education services?
Yes.
Thank you for that. Another question. So one of the other big concerns that are on here are the clinical experiences. When I look at the application and a lot of the pieces that you're missing here, help me understand the clinical experience requirements that you have in your program, and how are you going to be following the law as far as mentoring?
Great. Yes. So because the Apple program and board rule encourages flexible, if you'd like to adapt, put it out there. And Lisa told us we love working with innovative businesses and all, which we've really appreciated. We've put out several kind of trying to maximize a competency-based approach. So one of them, for instance, is I found that I often had candidates apply who came from non-traditional backgrounds. So maybe a wilderness therapy treatment center. And they may not, while that would absolutely not fulfill all the competencies, competencies like CC4 and LL5, where they, about trauma-based behavioral, let me find the exact wording here. Communicating clear expectations and procedures, including positive behavior interventions that promote student ownership of behavior. We feel that it falls within a competency-based approach to take a candidate like that and consider whether that might meet a few competencies. And the reason why, and again, we are willing to change that if that doesn't work for the board and for the staff. But we kind of put this out there because we think that adds to the a candidate's fitness for the classroom. We've found that candidates who have done non-traditional things like coding camps and other types of academic camps, that they bring a richness to the classroom that is different. So that's that's why we requested that. It looks like it is within board rule, so we thought we would try for that approach.
So to clarify, you don't meet the requirements now, but you're willing to meet the requirements. Is that what I basically heard you say?
So we put that out as a suggestion. We thought that it would work. If that doesn't work for staff, or if it doesn't meet the requirements, we are willing to work with staff to change that. We weren't aware that that would hold our proposal back. So in the spirit of being innovative and trying to maximize this framework, and we can speak to the other pieces as well, if you'd like.
Yeah. If I could add to that, these additional issues regarding the clinical experience, we thought we had worked it all out with the staff. And so when we saw that there were a couple items that did not yet meet approval, we were a little bit surprised. But we think it's actually simply because we didn't get deep enough in the conversation and providing enough detailed documentation on how exactly we plan to monitor and support candidates' clinical experiences in other states, as well as how we plan to, for candidates that secure their own placements, how we will communicate the requirements to those candidates. And so we believe that if we had the opportunity to provide a more detailed written documentation, that the staff would probably have been able to sign off on all of those. To that end, we have prepared our comprehensive internal documentation over our entire clinical experience. It's about 80 pages long, and it includes all of the details that anyone would ever want to see. We'd love to be able to make that available to the staff so that they can get all of their concerns satisfied. And we believe that when they see the rigor and the discipline that we've put into this program, that they will be able to be satisfied with those concerns.
You. So I apologize to the vice chair, but we did have a time certain for the assistant attorney general to address the committee. He has arrived, so if it's okay, I'll excuse everyone at the table and invite our AAGs, Laura and Darren, to come up. And again, just for those who are listening, we have a time certain for 9 o'clock regarding item 2.3. So we have temporarily paused the discussion on 2.4, and we will now be discussing item 2.3, Utah Professional Practices Advisory Commission. This is listed as an update. I know that the superintendent shared some thoughts and direction with us yesterday, and it's my understanding we'll be getting a bit more detail today. So with that, I will turn the time over to the AAGs. If you could just introduce yourselves for the record, we'll proceed from there. Thank you.
I'm Darren Goff, Assistant Attorney General, Education Division Director, and with me is
AAG Laura Cooper. I am assigned to USBE as one of your dedicated attorneys.
My experience here, I was initiated by fire, I guess, at my first board meeting last June, and I walked away with it from some thoughts about how can the Attorney General's office assist with improving this process, at least improving the process that you all are responsible for, the final decision making. And I think that starts with some discussion about what it means to be a final decision maker and what should we be doing and thinking about as we are rendering the final decision. Your process involves a complex fact-finding process that is essentially over before it gets to you. There are some limited circumstances in your rules where you can consider factual information, but for the most part, you function in a role that's akin to an appellate court. You are, the findings of fact have been made, the witnesses have been heard, the evidence has been submitted, and you're basically just double checking that recommendation and decision. Appellate courts, when they review factual determinations, conduct a limited review as to facts, and then a fairly extensive review as to the application of those facts to the law and the ultimate decision. So when you sit here as a quasi-appellate body, the things that I believe that you need to be looking at are, number one, were there procedural errors below that need to be addressed? And a procedural error could be the denial of a request to either admit or exclude evidence. Okay, let's say someone wants to admit evidence, and there's an argument that evidence is just irrelevant and completely off base, and the hearing officer doesn't permit it to come in. Well, that's something you can take a look at, as an appellate body would definitely be interested in making sure that decision was correct, whether your rules were followed, whether both parties had the opportunity that they're entitled to present their evidence. So that's one area of consideration. And then you kind of move on to what I would call the findings of fact and conclusions of law. When the UPAC process is concluded, there's a report generated. and a record that is essentially compiled. That record, when I talk about the record, I'm talking about the evidence, the facts that were submitted and heard, the witnesses who testified, the exhibits that were admitted, and findings of fact. Those are the determinations by that body as to what happened. Those are what findings of fact are, and they should be supported by the record. So there is a decision to be made as to whether or not the findings of fact are actually supported by the record. That is, frankly, not it's not an insignificant undertaking to determine whether there's support there, and we're looking at ways that that report could come to you with more definition and direct citations to the testimony, so it's not like this game of hide and seek. You know, I mean, if you have to play Where's Waldo with the findings of fact, that can be exhausting. They're typically there, but with a little bit of extra detail in the report, it's less of an undertaking to make that decision, to make that determination. Now, an appellate board does not spend a lot of time second guessing those findings. And the reason is that we legally believe that the person or the body in the best position to make these assessments is the body that actually heard the evidence. You can look at a record, a transcript of testimony, you can look at exhibits, and you can say, well, oh, yeah, that was said. But when it comes to making determinations about credibility, there's concepts of demeanor evidence. What did the witness, how did they seem when they were on the stand? Were they squirming? Were they struggling to answer questions? Did they seem, really uncomfortable? And often you have, two conflicting narratives, and making the assessment as to which one is correct. We lean on the in-person assessment to get to that spot. But we do want to know whether there was some evidence into the record to actually support this conclusion. But if the findings of fact have support in the record, we're kind of done with that discussion or with that determination. And then we move to a place where you have, I think, a much greater role, and that is, what we would, I guess, talk about is conclusions of law. Are the facts being properly applied to the law? Do the facts support? Do the facts as determined to be support the conclusion that misconduct occurred? And that's sort of that's a different inquiry and a deeper one. And then once that determination's made, what else should an appellate board be deciding? Well, whether the sanction is appropriate, were the proper presumptions applied? If not, what are the proper presumptions? If it's ambiguous, what are the factors that would mitigate or skew in favor of one presumption versus another? And then once that's determined, the ultimate decision, should we exercise our discretion and deviate from these presumptions in some way? That when we say presumption, that typically means, well, absent some other consideration, this is what should be applied. But we often talk in the law in terms of aggravation and aggravating factors and mitigating factors that you may want to consider. But those are the proper those are the types of considerations that a final decision maker should engage in when coming to trying to reach a final decision. Laura and I and Jeremy, my other colleague, was Jeremy here yesterday? Have they met him? I don't okay. Jeremy's our section director for public education, so he's Laura's direct supervisor and involved in these things. We've kind of talked about what could we do to try to help with this process and make it less aggravating and clearer as to what we need, what should be happening. And one thing we've sort of settled on is that in in contested matters with significant repercussions, significant professional repercussions for the educator, I'm proposing that our office conduct a review for you, acting as counsel to the board, and sort of check some boxes about whether these things occurred. Was there, basically create a form memorandum, review the record, review the report vis-a-vis the record, make a determination as to whether or not the findings of fact have support in the record or not, offer some direction as to whether or not the conclusions of law are correct. I skipped a step because I'm working without notes here. I'm without a net, Chair. Preliminary determination as to whether or not there are any, whether or not there are any procedural errors, and then whether or not the presumption that is being recommended is the correct presumption, and then what are the board's options at this point with the record in front of them. And the point of this, I think, is to you have the ability to review all of these to review all of these reports and review the record in every single one of them. I suspect that would be exhausting. And we want to at least, I view it as us kind of giving you a roadmap that you can then look at, and you're free to make your own determinations. These are simply recommendations. It's not us telling you what to do, but assuring you that at least from a legal perspective, these boxes seem to be have been checked and are appropriately marked off. And as I understand it, we would be engaging in this exercise in cases that are contested with license suspensions or revocations for 1 year or more. Right now, I think we're looking at probably 10 to 12 of these a year. Is that what you understand it to be? I think that's what I got from my conversations with the superintendent and with board member Carey.
That's what I understand.
Okay. So I guess I'd turn this back to you folks for questions and what can we do to help you?
Thank you, AG Goff. I appreciate the time and the effort that our AAGs and the superintendent have put into to fix these on a internal basis and internal control basis rather than through rule. I think that makes us more efficient and allows the implementation to be quicker. So I want to commend you for that. I will turn the time over to the committee. Are there any questions about what was shared with us today? Yeah, we're all looking. Carol, you can't see us, but we're looking at you to see if you.
She has the greatest presence in the room.
And yeah, this is really uncomfortable. I've never been this larger than life presence. I did have, I'm trying to think how to say this. My concern is, and I tried to say this to Laura last night, but it was A, late, and B, we hadn't had all the background, but I'm feeling there's a big gap between the suspensions of a year or more and revocations, and then all the other stuff, which is really most of the cases we deal with. And I'm not sure, and so I think I hear you saying that you would not be reviewing any of those in any way. And did I hear that wrong? Or would you have the sort of the general oversight that you've always had, that the AGs have always had? Or how would that be different, or would it be different at all?
No, remember, Lear, this is what we talked about last night. This is where we're going to start, because some of it's a manpower issue. It's going to be fairly exhaustive going through, even if there's only 10 or 12 a year, but the Hyatt case, for example, was well over 14 hours of audio to listen to, as well as going through evidence and everything. So it's going to come down to how much can we get done. If we find that we can get things done fairly efficiently and there's a need for it, we can certainly look at other cases, especially if requested on a case-by-case basis. We can expand it if we have the time and the manpower to do it, and there's a need for it. But we thought this was a good place to start to see. And the whole idea is not to stop giving you all help. It's to give you more focused help in this particular area, because this has been a concern that we've noticed.
Thanks. That does help. And I do recall that you said we'll start here and see where else we need to go, which that will be interesting to see
And
how that develops. Go ahead.
and it's certainly
I
not
had one more comment.
Go ahead.
Sorry, Darren. I had one more. No, I want to hear what you have to say, and then I had one more question. Go ahead.
It's certainly not a withdrawal of general service from the other matters. I would leave open the possibility that if there was a matter that doesn't fall in this window that is a particular concern, I don't see why the board couldn't elevate that and request the same treatment of a specific matter. But we do have staffing concerns, and the ability to really manage all of them. To treat everything this way would probably exhaust us. And our hope is that it creates a better process below to begin with. So
I think it sounds really helpful. I had one other question about, you said if these matters are contested. So there's an obvious answer to that it means if there's not a then we've called these things different names over different years. So forgive me, Ben, for probably not saying
Consent to discipline.
Recent. Yeah, consent to discipline. I was thinking of stipulated agreement, but either way. So if there's not a stipulated agreement or a consent to discipline, that would be the time that you would review it. If there's a year suspension or more. Is that what I'm understanding?
that's correct.
Okay. And would you do that review just on paper, or would you do it would you consult with the teacher's attorney or legal representation if the teacher has any, or it would just be a paper review essentially?
It's just
Is that right?
It's just a review of the record. I don't think it would be at all appropriate for us to have communication with either party. And again, this sort of brings me back to the first conversation that, what we're looking at here is the record. And if it's not in the record, it's not appropriate to be considering it. It needs to be in the record to be considered. So I would not see us having any communication with either UPAC or parties' attorneys. We're counsel to this board, and we're simply advising them as to what the record contains.
And I would
Okay.
note
That's-
that
that's- go ahead.
if we're going to advise you and you're bound to the four corners of the record, then we should be as well.
So, and not to, again, and I won't belabor this too much, but when you say you're bound by the record, you wouldn't look back into the underlying evidence, or you would look only at or maybe you would look, I don't want to put words in your mouth. What would you look back into the underlying information, or would you only
look at everything that would be considered in the record? That would be the report from UPAC, that would be the evidence that was admitted at the hearing, that would be the recording of the hearing, but we would not be going out and seeking additional evidence or trying to go outside of what is part of the record.
And then how would you provide that information to the board? Would you make would you provide a report, literally a written report?
There's going to be a written form memo that will, so they'll all be consistent, and you'll get the information that will say, we've reviewed this, we've reviewed the report, we see that there is support for the findings of fact, we see that there is support, or there's not support for whatever conclusions have been drawn. And so you have that information going into your meeting, so when you discuss, you have that in front of you.
Okay.
I've described the, I'm sorry.
No, I had something else. It's hard. I hate being online, but I had one other thing, but maybe I'll come to me as you keep talking for a minute. Darren?
I've described this to Board Member Carey and to Chair Hymas as the equivalent of a bench memo. That might mean something to you, Board Member Lear, but in appellate judges have clerks that put together this exact information for them when they're reviewing a case. And it'll be the same thing. You'll see it it'll be the same form every time. I don't think it's going to be more than 2 or 3 pages. So.
And you're not going to go backwards and look at anything. This will be just going forward, right?
Meaning cases that have yet to be presented, correct?
Right. Right. I had some other question, but I can't think of it now. So I'll either send it to Laura in a email if it comes to me, and I still think it's important. I think it sounds like a wonderful service, a great service from the AAGs, and would be something that's very specific and very helpful, and a great idea. So thank you for offering those observations.
Well, and one of the things that you'll get out of it is if we see problems that we think are going to cause further problems down the road, we'll flag those for you. It's still up to you what you do about it. But if we see things that we think may cause legal issues, we'll definitely bring them to your attention so you'll know about it going into it.
Thank you. I remembered my other concern, if that's okay, Joe. I'm not trying to, if other people have questions, I can't see them, so just cut me off. But
no, please, Carol, go ahead.
I had one other concern, or one other thought, that where I thought the AAGs could be very helpful. And that was, I wonder if you would be willing, and I don't know what this would look like right now, but it sounds like we're going to have a whole new group, maybe a company with employees, certainly two brand new investigators. I'm wondering if both of you or other people as assigned would be able to work with those individuals and help train them in investigative techniques and train them consistent with the rules that we have. That's one thing that's, I think, been missing for decades in this process, is a real helpful and professional, and no reflection on any of the past directors, Ben, and me as well, but myself as well, I should say. But I just think it would be so helpful, especially with Laura's background, to have some training for the investigators and help them do it better, so that your role toward the board would be also streamlined, I think. Is that something that's possible?
I don't know if they're in a position to answer that. I mean, but if you're willing to take on the additional work at no extra pay, as we're prone to do, then please.
No, why should they be any different than educators?
Well, yeah, it's not extra pay. It's just the same pay. I think we're always receptive to, I mean, training is a component. I'd need to think about, what that would look like. And I want to also make it, pretty clear that we're not, that the investigators should be little bit distant from us in this process because we advise you as final decision makers. And if I'm advising investigators at the same time, then it starts to get squirrely. But a general training, I think, would be appropriate, and maybe the education division. The education division commonly takes those sorts of tasks on, but I'd probably want to cross that bridge after, with some consideration and consultation with UPAC itself. And
Sure.
maybe, there are other resources as well. We have risk management provides comprehensive training in other areas. So we could maybe look at that as well.
Yeah, and I'm just asking you to think about it. I see it as something that's been lacking, and would be helpful to have some consistent procedures that are developed from the beginning with these new individuals. So just think about it, see what your resources are. But I think looking at it from over several decades, it's something that has really been missing that would be helpful.
Thank you.
Not seeing
Thank
any,
you for the consideration.
Thank you,
Go ahead.
Board Member Lear. Not seeing any other lights. I take that back. Vice Chair Bollinger.
So I just want to make a comment. I just want to say thank you. Thank you for your support. Thank you for helping us find a way that we can improve our processes. I know that as we're trying to improve oversight and accountability, which is one of our priorities in our strategic plan, you're helping us do that. So I just want to express my gratitude, not just for myself, but for the board. Thank you.
Thank you. And I just want to say, I think that, this is the way the system is supposed to work. I think that several areas have been identified for possible improvement. And I think that not only will we see an improvement in the issues that you've outlined, but I think there will be a positive cascading effect into making this part of the responsibilities of USBE more efficient and more attuned to some of the due process areas that our educators are entitled to. So thank you to you. Thank you to the superintendent for moving in that regard. Thank you very much. Okay, thank you. So that was item 2.3. I thank the Assistant Attorney Generals for their time this morning. I know they're very busy. And with that, we will bring Coordinator McLaughlin and the individuals from Alcott Learning back to the table. And then with that, I believe that Vice Chair Bollinger, were you in the middle of questioning? Okay.
Thank you, Chair. All right, going back to my questions. And again, I have a lot of questions but I just want to make sure that when we make decisions, they set precedents, right? And we want to make sure our role as board members is to serve our K-12 students in the state of Utah. So that's where my focus is coming from. So let me just front load my questions and comments with that. And having high standards for all of our teachers is something that's important, that we're consistent. So with that, when we are kind of talking about mentoring, and it sounds like you guys, I mean, in your application, here's a question under mentor selection. So I'm on the top of page 32. It says, has a minimum of 2 years of successful teaching experience, 3 or more years preferred. So my concern with that is that in R277308, which is one of our own board rules, our own mentors in the state of Utah in our K-12 schools have to have a professional license for at least 3 years. So nobody can be a mentor unless they've been teaching for at least 3 years. The way that your program is set up does not meet that criteria. So that's something for you just to have on your radar. And that not only that, but they have to have a professional license to be a mentor, not just 3 years of experience. So help me understand how, especially because you're looking at trying to open this up to non-traditional settings, as you said. So micro schools, homeschool, outside of the state, how do you ensure that they have a professional license?
Yes. So this is the first time we've heard that concern. It would definitely be willing to make adjustments based on that. So thank you for bringing that up. In terms of those technical details, I think we could make adjustments there.
Yeah, let me jump in and share as well. So one of the principles that we operate with is verification. So we verify everything. If someone gives us a reference for a previous teaching position that they are trying to leverage to get some competency during the intake prior to the PLP creation, we have some specific protocols where we require them to give us information that we can then independently verify and then independently contact to confirm that we are actually indeed talking to the correct administrators at, et cetera. We follow similar protocols for any information that is important to preserve the integrity of the Apple program, and including that would be including verifying the credentials. It says specifically the mentor educator needs to hold a professional license, and so we would independently verify in whatever way is thorough and appropriate for the circumstances that they do in fact hold a professional license in their jurisdiction, and that additionally we would pay attention to other details to make sure that we feel that it's valid, credible, and preserving the integrity of the program. Does that answer your question?
Can I add to that as well, just quickly? We are willing to deprioritize all of these non-traditional settings and all. We felt like that would be a great way to bring richness into the classroom, but we are absolutely focused on Utah. And as you can tell by everyone we've met with and the different schools and all, we want to help Utah teachers. That's what we're here for. And so we have added that as a part of our proposal, but fully willing to deprioritize that, and it's not our focus.
Thank you. And I think that's one of my biggest concerns is we're opening Pandora's box with the way that you've proposed this. If I may direct a question to Dr. Haidt. So currently, if my understanding is that if a teacher is in the current Apple program, they have to be a teacher of license, or a teacher of record, I think is the wording.
Malia Hyde, Executive Coordinator of Educator Licensing. That actually is not true.
Okay.
It's up to the Apple program to determine whether or not they are a teacher of record.
Okay, so they have that flexibility to see that. Okay, if I may continue, and if somebody else wants a turn, I can take a break and come back. Okay, I'm taking Carol's role today on this. Okay, so one of the other things, so when we look at an Apple program, typically we have an alternative program just to make sure we get highly qualified licensed teachers in our classrooms. Typically, this adjusts and changes based on the needs in our current education environment. When there's a teacher shortage, you'll see kind of the requirements become looser. We provide more opportunities and pathways. We are currently not in a teacher shortage. There was an article the other day, 150 applicants for one position. Right? So there are teachers. In fact, I've talked to several teachers that have been trying to get a job for 2 or 3 years, right? Because there's competitive. However, there are areas that still have gaps, one of them being special education. One of the things that is in our rule, R277304, is to make sure that the teachers can show competencies in essential elements. Tell me how your program, I didn't see that addressed in your application. And I apologize if I missed it. How are they addressing essential elements?
And by that, do you mean, the essential elements, so literacy?
No, essential elements are the standards for special education students with severe disabilities.
Yes, so we are actually not going to be addressing special ed in our program. We're just not qualified to do that. So as we, potentially expand, we would love to help out with that gap. But right now, that's just not in our wheelhouse. So we're not addressing that need. But we would like to, and like you said, we saw that on the news as well, 150 applicants. We know that because of the competency-based approach, there's not a shortage in the same way there is in other states. But we do see a need for different areas in the state to have, so we're seeing 3 things. One, districts, rural, smaller districts and all needing help. Two, as a former charter school director, it was very hard when our school was small to wear so many hats and to do so many things. And the entire Utah Charter Network right now, they do not have a partner to help them with Apple. And as I shared earlier, the burdens as we met with directors are very heavy. And even though this is a great program, the Apple program is amazing, it's the best of its kind, it is still a lot on these schools. And they were very welcoming to the idea of if we could turn this over, we would love to. And so, and especially because I've been in their seat before, they know that I really know what needs to happen for the classroom. So those were the main gaps that we feel like we can fill, and we are seeing but at the same time, I want to say we absolutely believe in the rigor, the necessary rigor and integrity of this program. We're not looking to lower standards in any way, but to be truly competency-based and independently verify evidence, all of that, keep all of those records. We have an extensive plan for how we would do that and how we would communicate with those teams. So Josh has our list, but we have, I think, 8 ways that we'll be communicating regularly with the teams. And I know that the UACPS, that they use a similar type of approach.
Okay,
Yeah.
thank you. And so, I mean, I'm glad you brought that up, because I do know that many of our charters do use UAPCS, so that's allowed in our rule where they're working through an association. What would stop you from independently contracting with the Utah Charter Network?
So, so what would stop us from it?
Right. I'm saying, why are you coming this pathway instead of looking to, because there's nothing preventing you from being a subcontractor and them creating a consortium and then you supporting that. So there's a pathway for that following the rule. Wondering why you're looking for an exception to what the current option is.
Yes. So 2 thoughts on that. One, we don't see ourselves as an exception because there are other programs like us out there, but also because we would love to have the flexibility to help everyone we can. So if we were just at UCN, we couldn't help, Christine Fitzgerald, Superintendent Fitzgerald in San Juan. So we really want to just find everyone who needs us. We also know there are other Apple programs that are not compliant right now, and probably just because they're overwhelmed. And so we would love to be able to take on that administrative burden for them and help them get great people in the classroom.
So to follow up, I mean, you mentioned, like San Juan, there's nothing to prevent them from subcontracting with you either, correct? Because they can have their own Apple program as an LEA or whatever. Same with our REISs, right? A lot of our REISs serve our rural schools and have that. So this is where I'm trying to think, what's the need? Are you following all of our rules, right?
Yes.
And even just the expectations, that's what I'm looking at as far as your appeal, correct?
Yeah.
So another question, it also says in R277304 that the teachers have to be able to show competency in Utah core standards. How are you going to do that with all the candidates outside of out of Utah that you're going to be working with?
Yes. Okay, that's a great question. And just to follow up on your first point there, so we're also hearing that a lot of the pain is not just in getting great courses, it's in that sort of Sherpa experience, like guiding them through the administrative process, that there's some real dissatisfaction around the options currently related to that. And so if we're not an Apple program, we can't do much to help there. If we are an Apple program, I mean, I would say probably that's more of the issue that we're hearing. Now, we believe we can bring substantial, help and better quality into courses because I've worked with so many teachers in this exact way, but we would love to create a much smoother experience, just a better system for getting them through the process.
Yeah. And then before we move to the next question, may I just add as well? So it sounds like there's still an open question, at least in some people's minds, about the board rule that R27730325B, which uses the term may include. And as we read that, and you can help us understand if we've misread it or misunderstood it, within that same board rule, private schools and consortiums of private schools are also allowed to administer Apple programs. And as we shared earlier, there are for-profit LLCs and a variety of different business entity types currently approved in the Apple program. If we read may include as an exclusive list, we do run into some pretty bad inconsistencies within the rule. And we also run into a situation where we've got a lot of Apple programs that are currently operating that are technically not allowed to. So we're having trouble finding any way to read that except for a non-exclusive list. So we do feel like we pass muster with respect to the definition of an EPP.
And see, I see it a little bit differently because I see it serving K-12 public education students. So even those ones like you were talking about, the teacher development services, those are still our K-12 students, where what you're looking at is micro schools, you're looking at out-of-state candidates, you're looking at homeschool parents. And let me be clear, I love what you're doing as far as we want to have highly trained people supporting our students. That's something I 100% get behind. What I have to look at is our role again. K-12 public education is our role. And so those supports and services that we provide need to be focused on that. So because your application is so broad and is to service so many entities and things like that, that's really more of the concern than the actual entity piece. It's how you're serving the students. And with that, I would say, with my understanding, and maybe Dr. Haidt can help me understand this, but when we have individuals come through our licensing program, let's say like the Apple, we were to open this up, they get free background checks in the state of Utah. Is that correct?
Yes. All educators who receive a license have a background check that we pay for that processing, and it's a nationwide background check.
So with that, if we were to open this up to all like different entities, homeschool, outside of the state, is that costing us taxpayer dollars to do that for a for-profit company?
Yeah, every background check, every educator who has a background check performed, it's $44.10.
Right. So that's also a concern for me.
And rightly so. I definitely understand that. And again, we're willing to deprioritize that. It was not the biggest piece in our proposal, and we haven't experienced a lot of pushback with that in our meetings. So this is a little bit new for us, realizing that this is a big issue, but we absolutely want to focus again. Charter schools, are public schools, right? And our main the interest that we're getting is mainly from those schools, and the need we're hearing is massive, and that's Utah, public schools, right? But again, we're willing to help everywhere we can and keep that focus. So we're willing to deprioritize that and to work with you on that for sure.
Yeah. And if I may, and we definitely understand that concern. What we've tried to do, and maybe it's because we're a little ignorant of the process, is we've tried to understand the board rule and then write an application that satisfies all the restrictions that the board rule gives us. We feel that everything we've proposed is supported by board rule, whether or not it feels like the climate matches the requests or not. But we do feel like everything we have requested or proposed is actually supported by board rule. And so we definitely, there's no part of our application that we feel that we're trying to get especially clever on. We've just tried to understand the rule and find opportunities where we can make a difference that potentially are not being filled or served by the other Apple programs.
Okay, well, and I appreciate that. And I'll have one more question, then looks like Member Lear is ready to ask some questions. The other piece when we talk about, speaking of the rule, so I appreciate you bringing that up. So I'm in R277-304-4 under section 3. It says includes school-based clinical experiences for a candidate to observe practice skills and reflect on teaching that are significant in number, depth, breadth, and duration, are progressively more complex, and including working with all types of students. So in your program, do you have that built in your application that they get an opportunity to work with all different types of students?
Absolutely. So the way, as we understand it, the USBE is defining that it can be learning differences, it can be demographic differences, anything along those lines. That's built into the competencies, and so it would be an absolute guarantee to meet the competencies.
And how does that work with school-based if you're going to do homeschool?
Well, we don't have any homeschool proposal there. So the micro schools, there are micro schools, for instance, Prenda is one of them, where they have licensed teachers. Some are licensed, some are unlicensed. We have no intention to work with homeschool. We are hoping to do a certification for homeschool parents at some point, but totally separate from licensure. I've worked with a lot of home-based ed families, but we have no desire here to extend this
And
right now.
And just to clarify, in case there's still a misunderstanding on what we meant by home-based ed, if a homeschool teacher wanted to become a licensed teacher, they would have to do a clinical experience in a approved setting. It's not something that they could do in their own environment. The rules are very strict. It has to follow exactly the Apple program guidelines, and so we're not deviating from that at all.
Meaning we wouldn't especially include them or exclude them if they meet the standards and they're trying to get licensed, great, but it's not one of our criteria, nor is it an audience we're looking to especially move into licensing with.
And I believe that's consistent with how it works now across all Apple programs. It doesn't really matter your background or your entry point. The rules are the rules, and they have to be consistently enforced, and we intend to do that with precision and rigor. And that means that anybody can come through the front door, and only those people that satisfy all of the competencies in a very clear, demonstrable way will be recommended for licensure.
Appreciate it. Thank you.
Thank you. A board member leader, before we get to you, I just want to follow up on one thing that Vice Chair Bollinger said, and it goes back to the interpretation of the rules. So I want to make sure that I understand this adequately. I'm reading an email dated August 4th. Today's the 7th, so this was sent 3 days ago from Lisa McLaughlin to, it looks like, Liz and Josh, both of you. And it says this email is to notify you that USBE staff have reviewed the Alcott Learning Apple application you submitted and have denied your application for the following reasons. And we understand that because you said you were here on appeal. You're appealing that decision. And it lists just 2 reasons why your application was denied. Right. And so I'm hearing a lot of additional concerns, and that's the prerogative of the committee, right? I mean, that's why we're here. It's not to rubber stamp, it's to make sure that this committee is satisfied with your application. But I just want to address one of the 2 things because I thought this was settled, but now I'm unsure. And it says your entity, and I assume that means Alcott Learning, your entity does not meet the definition of educator preparation program in R277303. So whoever's driving, can we call up R277-303? And while you're opening that up, it says, board rule says a program is developed by or associated with an institution of higher education, individual LEA, a consortium of LEAs, or the board. So we're looking at 5A, educator, and Director Rasmussen said this at the beginning, educator preparation program means a comprehensive program administered by an entity that is intended to prepare individuals to meet the requirements for a Utah professional license or license area of concentration. So but you're not citing that provision, you're citing 5B. And you're saying that an educator preparation program may include, it's not directive in that it's not a shall include, it may include a program developed by or associated with an institution of higher education, individual LEA, a consortium LEAs, or the board. So I guess my question, I don't know if this is to you, Coordinator McLaughlin, or to Director Rasmussen, but what part of 5B are we saying that they have failed to comply with? Is it that they're not these things, or they're not associated with these things? Does that question make sense? I see, Director, you have your light on. Could you just respond to that, please?
I mean, 5B does have some flexibility, but I look at it as an illustrative list of the types of entities that can be approved for an educator preparation program. Private concern that's not associated with an educational institution like those specified does not fall under any of the examples that are specifically mentioned, nor is it similar to any of the examples that are specifically mentioned. And that's why in my discussions with staff, I had concerns with this application and said this should not be something that we approve. If it's approved, it should be the board that approves it, because this is not similar to the language the board has adopted heretofore.
Thank you. That's very helpful. So we're not saying that it's prohibited by the rule. We're just saying that when we look at these 5 things, one is unlike the other. Is that correct?
I think this is a rule that 15 attorneys could interpret 15 different ways.
Probably 18 different ways. So, and again, I don't mean to delay. As the chair, I think I owe it to the committee to have their questions, but I'm just trying to understand this part of it, because if this falls a certain way, then I know how I'm going to proceed in my vote. But so my question is, are we saying that because it's a for-profit entity, is it the recommendation that as a for-profit, it can't be approved because it doesn't fit this definition? Or are we saying it just means it's different and that's why it's here before this body?
It's here before this body because it's different. I think I've indicated that if the committee interprets the rule to be more expansive than staff has interpreted it, or at least that I've counseled staff to interpret it, you're more welcome to grant the appeal and direct staff to approve the program.
And I understand that it's different, but is it different because it's a for-profit or because we're saying it's not associated with?
It's not it's not an educational entity in any way of any of the types specified, and it's not associated with one.
Okay. Coordinator McLaughlin?
Yeah, I along with what Ben has said, that it's that association that we had some concerns about.
That's what I'm...
all of the other programs that have been approved, like the teacher development services, are consortiums of private schools that already have agreements with USBE. And like the charter schools is the consortium that with the Utah Association of Public Charter Schools already has agreements with those charter schools that are established, and I think they're legally binding and they're paying fees and that kind of stuff. So this one was a little bit unique in that they had the potential to have associations, but they didn't have them established to that extent. And so that's part of what we were asking about.
Okay, that helps them because I am looking at this teacher development system, which the applicant is saying, look, they're for-profit. They have, and I'm looking at their website, School Systems Consulting, Apple Licensure Pathway. So that does help me. So we're saying that, look, they don't have, from our perspective, meaning the agency, this association established now. Because of that, that gives us pause. That's why we're here. And even though the rule doesn't say they have to have it, it's different enough where we're saying out of an abundance of caution, let's run it through the committee. That's very helpful. Thank you. Board Member Lear, please go ahead.
Thank you. I want to say at the outset that I don't pretend to be an expert in this area. I really look to people like Amanda who work in it daily to help me understand the details of how these programs work, and also of course, our own staff members that are working in this on a daily basis. But I didn't hear the answer to a question that Amanda asked much earlier. where it seems like if you've got a for-profit entity like Alcott, it'd be a very natural thing for you to subcontract with a RISA or the charter school network and provide your services that way. I didn't ever hear an answer to why don't you do that? And I guess that would be to Liz.
Yes, thank you for the question, for reminding us of that question. So the main reason is that, from what I understand, with that type of approach, we could only provide courses, which is an important piece of what we're doing. But what we're really hearing from a lot of the administrators and all is that they need help with the full Apple program. So what we're calling kind of the Sherpa side, guiding them through the creation of the PLP. We talked with several people who've been through different Apple programs about the pain points. And one of them said to us, I had to go to 12 different people to figure out what to do. Now, that's probably not because the Apple program couldn't have helped him better. It's that it wasn't a smooth administrative process. And that is something that we're hearing again and again, is that administrative load on the executive directors and on the candidates. It's just not been a smooth process. And so for that reason, and then the other piece there is that we would just like to help a lot of different people. So again, rural district schools, Apple programs that are out of compliance. And if we only worked with UCN, we would be limited to that role only. And we would love to, help as many people as we can.
But you could subcontract with UCN, you could subcontract with San Juan School District, you could subcontract with RISAs, you could subcontract with all of those individually. And my understanding is you could offer to provide whatever services they need. If they need the Sherpa-like services, you could provide those. And that just seems a more natural role for a nonprofit or for a for-profit entity, as opposed to something else. No, as opposed to what you're looking for. I have a couple more questions that kind of are companions to that, but go ahead if you have a thought about that.
Thank you. And my apologies. Maybe I'm missing the difference there, the subtlety there. But I feel like I think that's what we would be doing, right? Is subcontracting with all of these different entities like UCN, like the district. So maybe I'm missing a nuance there.
And I may be too. It doesn't seem that, it seems like there's some other role that you want to play other than as a subcontractor. I'm not sure.
As far as I understand it, and maybe Lisa or others could speak to this, I think that's exactly what the role we would be doing, is the role that you've stated. So we would just be subcontracting and working with each of these. In fact, we were even given a subcontracting form from Lisa that would help us create those relationships. And so I do believe that is the role we would be taking. No additional role.
And I may be just being, I don't know enough maybe, but that doesn't seem like what you're asking for. But, okay, we'll accept that for a minute. Can I just ask a couple more questions, Chair?
Please.
Carrie, is that okay?
Please, Board Member Lear.
What, and this is to Malia. Malia, if you don't mind, if I can ask you this question through the chair. What role do you play with these approved Apple programs? What kind do you supervise them? How active is that? Can you give me a little more insight about that?
Thank you for the question. I think that Lisa McLaughlin, our educator preparation program, is better poised to answer that question.
That's great. Thanks.
So we do periodic reviews of programs. We do try and do at least 20% every year. But there are some programs after we review them that require additional support. And so we'll often go in and provide that review every year as a checkup. All of our Apple programs and all of our university programs are reviewed at least on a 5-year basis. So we don't usually let them go 5 years without a review, but we'll do as many as we can that staff time allows.
And are all of those that you review, provide your services to, your oversight to, are they all not for profit? They're all other education, public education entities or parts thereof. Is that right?
Yeah, the majority of the programs are either institutions of higher ed or they're LEAs as running as approved programs. So the ones that we've mentioned, Teacher Development Services, I believe is a nonprofit and
Gotcha.
or for-profit. Okay.
For-profit.
And then Utah Association of Public Charter Schools, I believe, is a nonprofit. But they are set up similar to what these guys are proposing is that they run through a private organization, and that is the program that we're reviewing. So we would review, for example, Royce Van Tassel and his staff will go in and review the files in their organization and ensure that they are providing the support to their candidates. All of their candidates, so they run as a consortium, meaning that the LEAs partner with them and they sign statement of assurances saying they're going to help their candidates be placed in these schools. They're going to provide the clinical experiences for them to demonstrate the competencies. And then the program will provide administrative oversight and counseling for the candidates as they go through the program. And we'll review all of those aspects of it.
Okay. All right. And as a public school employee, that seems appropriate that you oversee entities that are working not for profit and with other public school entities. So that seems appropriate to me. One more. Shoot, and I'm kind of losing my train of thought here. I had one more issue with the. I was going to ask Liz. So you've mentioned San Juan School District several times, which is part of ERISA, as I understand it, and could get these services through what we used to call regional service center. But is there any other school district that has expressed interest in working with you?
Yes. So the charters, of course, as public schools.
Right.
And then we have reached out to 15 superintendents, and we have not received much communication back. And so that's why I mentioned San Juan, because we have an appointment set up with Superintendent Fitzgerald there. But we would love to work with them and help. We think because they have we think it may take a little longer to let them know what we can do and how we can be helpful. But we do know that there are districts that aren't necessarily, that don't necessarily have Apple programs at this point. So we would love to work with them.
Thanks. But you don't have any other school districts right now that have expressed interest. Is that right?
That's right. So the charters are the public, yes, schools that we have.
I absolutely understand that charters are public schools and that they've expressed interest. I get that. I just was looking for other school district, and I'm wondering if that's because there really isn't a teacher shortage, and that is so. This is kind of not an immediate concern for school districts that have plenty of teacher applicants, but that's just a speculation.
Yes.
Thank you. Those are the concerns and questions I had. Thanks.
Thank you so much. And just to speak to that last point quickly, while, like you said, maybe the districts are getting a lot of the candidates they want there, again, because there is so much response from the public charters, we feel like there is a really strong public need there, or we wouldn't, be hearing from so many, I think 14 directors now that have said, we would love to work with you right away. So we feel that's a very strong, deep need or evidence of that. Thank you so much.
I do have just a handful of questions, and I just want to say that this is as the Lisa said and Director Rasmussen said, it's a new issue, and so I don't want you to take any of the questions as hostile or creating an immutable position in any of the committee members. I think there really is just how do we move forward with what's best? And so I commend you for thinking outside of the box. I think public education needs more of that. I think a lot of our problems with public education comes from a groupthink mentality. And so I commend you for thinking outside of the box. And there's no requirement for there to be a teacher shortage. I've read the rule 4 times now, and I don't even see a footnote saying, unless there's a teacher shortage, we can't do these programs. But again, the staff's considerations carry a lot of weight. One, I think we addressed, which was this association. And I get it. And if we can just call up the rule again, I understand our rule doesn't say you shall have this association. It says may. But where is that? 5B. And that was one of the reasons that we cited, saying, look, is it dispositive? Can we deny this appeal because you're not associated? No, the board has discretion, and that's why you're here on this appeal. But I think there is wisdom in being associated with. And I looked in the record and backup, and I saw the 2 letters that you have, and it looks like the 2 organizations that you've heard from. The Utah Charter Network, it says there's over 100 schools in it. And then the other one is Canyon Grove Academy. But as I look at both of those, and it's kind of like the chicken and the egg, because I read those and I don't see that you're associated with. Because the letters are very prospective. It's clear that Kim Frank and the representative, it's clear that they're excited about what you're doing. They want to learn more. But I don't see the, yes, we're happy to partner with you. We're happy to associate with you. Let's do something. But I can understand that. And I understand it because you're not approved. So I get who's going to run out and say, let's associate when you're not approved to do anything. So I understand that balance, but it would be more persuasive to me to read something that says, if you're approved, we would welcome an association with you and, to move forward with this program. But this seems very, what did Winston Churchill say about tea? Not warm enough to drink, not cold enough to throw out, right? Like you're just in this area, but I get it because you're not approved. Who's going to make that commitment? But regardless of how the committee votes, this goes to the full board. And so I would just encourage you, and I'm going to vote to support your application, but I'm going to do it with the understanding that there needs to be, for my vote at the board, I need to see something that says, look, we love what you're doing, but we can't do it now, but should you be approved? Yeah, we're happy to look at this and associate. Again, I think that the rule doesn't say partner. It doesn't say we have to work together. I think we use the word associated with the understanding that we need some distance there, right? Because no one's going to partner with or make a deal with a group that isn't approved to do anything. So I would do that. The other thing is, and I said this email from our staff says, look, there's 2 reasons why you're being denied. One was this association. The second one, and I think that Vice Chair Bollinger's questions brought some of this out, but again, for me, this has to be, did we lose Carol or she just got tired of listening to me? I just want to make sure that she's still able to. Okay, good. Thank you. So I just want to make sure number 2 says the program's application intends to place candidates in clinical experiences that include, and they're quoting now from your application, non-traditional settings and multi-state clinical experience. And I think, again, Vice Chair Bollinger's questions raised both of these issues, which I interpret as our rule says that board rule limits clinical experience settings to pre-K-12 classroom settings. So to the extent that your program doesn't do that now, I would suggest that you bring that into alignment. And if it does, great, just report that to the full board. But to the extent that it doesn't, and our staff seems to be suggesting that it doesn't, I would bring that into alignment. And the other issue that Vice Chair Bollinger brought up, and I believe, this is my interpretation, that the multi-state clinical experience, I think it goes to that notion that if you're out there licensing all these individuals and the state of Utah is getting the tab for that, that's not your fault. I believe state law says that we can't charge. Is that correct? Like the state of Utah, if you want to blame someone, blame them because they're saying that we have to pay for that. But I do believe that's a heavy burden for, and again, it's one of those things when you pass the law, you think, we've got this, we've got this all figured out. We're going to do something nice for educators. We're going to pay. But in reality, we probably weren't thinking about, well, what happens if we are licensing individuals who may never come here. I do believe that's a burden that has to be looked at and addressed. So, again, I'm less concerned that, well, this isn't the way that I would design a program, right? This isn't the way I would train teachers. Our rule doesn't require that. It just requires you to meet the standard. And from the reasons of the denial that I'm looking at, you've done a great job. We've only raised 2. So to that extent, I would ask you to focus on those things. And again, that's my request. But I would also encourage you to reach out to every member of this committee, as well as the board, and listen to and address the concerns that they have, the concerns that Coordinator McLaughlin may have and Dr. Height may have. But that's what's going to be looked at and addressed at the full board in September. So, are there any other? Member Longacre.
Thank you so much. And this question is directed to staff, if you guys don't mind. Are there any other teacher prep program standards other than the ones that are indicated that are not met on this application?
No. So we've been through all of the other requirements in the board rule, and the plans and the application that we reviewed have been met to staff satisfaction.
Okay, and I guess this isn't a question, but I'm wondering what your thoughts are. There are some concerns, some valid concerns that have been addressed. Would you guys be opposed to taking another month, addressing our concerns, and then coming back? Because I think it would look better if this proposal came out of our committee with more of an approval rating, and then it going to the full board. That's just my 2 cents. I thought I'd throw that out there.
Thank you so much. So we have spent about 8 months on this. So sorry. It's a tremendous financial burden for us. It's been thousands of hours of work. I'm so sorry. I'm embarrassed. I'm sorry. I don't know that we can continue to run this through. We want to do this good, and we work very hard for it. It would be very hard for us to continue. So I'm so sorry. I am a crier, so please ignore it. Thank you so much. But so we would love to have the next 30 days to resolve every concern possible and be able to come through in the next board meeting, if possible. But I do appreciate that it might be an advantage to us to wait another month. But yeah, it would be very hard to do, to take through another 2-month cycle. And it sounds like a short amount of time, but I think you could probably understand the amount of stress. So, thank you. Sorry. My apologies.
Chair, if I may.
please, Vice Chair Bollinger.
Thank you. I'm sure this has been a big lift. I mean, I can see the details, and then there's another 80 pages, it sounds like, that you've done that. It's hard for me, though, to pass something through as the what ifs or the hope for. And when I'm representing the state of Utah, my constituents, and the tax dollars they're using, I also don't want to use the time that it costs the board and everybody here, because I know a lot of our staff's been helping support, right? Like that costs us taxpayer dollars to then have the same, conclusion and concerns. And I think that Chair Carey did a great job identifying the things that are still a concern. And I will tell you, as a practitioner, I have a lot of people, vendors, that reach out to me and say, hey, I have this free something. I have this free something. As I read, you present this as if you have people interested, but the interest is coming from an email that says, hey, we're going to pilot this and we can help one of your teachers for free. Are you interested? And they say, yes, I'm interested. I would be interested too, as a practitioner. Doesn't, to Chair Carey's point, doesn't mean that you have anybody solidified. San Juan is already part of the Reese's Apple program. So yes, they're interested, because if they can send a teacher for free, then yeah, why wouldn't they? And so I think that this is also misrepresented into the actual need or group of LEAs or consortium that I think you're overestimating potentially and maybe I'm wrong, but I would like to see evidence that people are willing to partner and committed to doing it to meet that requirement of the rule.
I think you're absolutely right about that. And to that point, we actually, I think we have I think that we've represented it accurately, but out of respect also for USBE, we didn't want to say to people, will you sign something that says you've we've talked with Lisa about using caution when it comes to what we can promise to schools.
Right.
And so I have full confidence that we could get them to, in fact, Kim Frank reached out to me yesterday and she said, what else do you need from me? Can I send a full thing with you? And I said, I don't know if it would be quite appropriate yet. And so we would love to have the next 30 days to, get some deeper evidence of the associations that we have with them, and also resolve these issues with staff. We feel confident about being able to do that. And because of the enthusiasm that they've shown. So with this, Lisa brought up the issue in a meeting, and I said, I'll get them to you as quickly as I could. I wrote 3, so there's also Heidi Long from Ignite Entrepreneurship Academy as well in those emails. And within 5 minutes, I had those emails from them. Yes, what else can we do? We're so excited. And so we feel very confident that we could bring those in 30 days. We could bring them in 2 days if needed.
Well, with that, I'm actually going to be a no today. I'd like to see some refinement of this. And like Member Longaker said, I could support postponing it a month to committee, but I'm not going to vote something to go through when it's not prepared for the full board. I think all of us yesterday, we were there till midnight because we had things that weren't prepared and ready to go, and we were trying to make adjustments. So I agree with Member Longaker that I'd love for this to come out of committee with support. And I'm sure that's emotional. I'm sure you've been leading up to this, and I'm sure there's a financial burden that's part of the thing. And I can tell you've put your heart and soul into this. And I applaud you for just the passion that you have to help support teachers, to help support students. And that's something that I think everybody on this committee can commend you for and support you for. But we also are responsible for, again, K-12 Utah students. Your application is way beyond that scope. And I'd like to see the 2 concerns addressed, as well as some of the other things that we're talking about, like that. If you're looking outside of the state of Utah, great. That won't prevent you from doing that on your own outside of an Apple program. But in an Apple program, I would like us to focus on K-12 Utah students.
Okay, with that, Board Member Lear, your hand is up. Do you have a new question, or is that a yes? So Board Member Lear?
I do. It's just a comment. I don't need a response. I was looking for an analogy to this program, and the nearest one I could think of, again, with my limited expertise in the area, but I know a fair amount about WGU. And so I asked Dr. Haidt yesterday, I said, is this kind of similar to a preparation program that WGU has which is, again, serves students throughout the United States. It's obviously much bigger, but it's for profit, definitely for profit. And yet there is a kind of general oversight approval process through the USBE for WGU. And Malia mentioned to me then, she said, because I was looking for, if the board starts to supervise for-profit entities, when our responsibility per the Constitution is for not only K-12 students, but K-12 students in public education, then we should be carefully looking at those resources. And so Malia said to me about WGU, she said, but WGU gives the state hundreds of thousands of dollars, and literally I hope I'm quoting you correctly, Malia, in teacher scholarships in order to participate in the various programs that WGU has. So there is a return to K-12 public schools through working with that nonprofit in a similar kind of role, the most similar that I could think of. So that's what my concern is right now, is our limited resources, the time resources of our staff. And I'm not prepared to support this. And Chair Carey made a point about it's not required that there's a teacher need, but if there were a dramatic teacher need, I'd be more willing to stretch our staff beyond what they're already doing. And I don't see that need right now. So I'm not a yes, and I can't support stretching our staff to oversee a vendor, essentially, right now. I'm not saying I'm not open to changes or other permutations, but right now I'm not ready to approve that. Thanks.
Thank you, Board Member Lear. Not seeing any other lights, I'll make the motion on this one. Yeah, please, Director. Thank you. And again, just by way of preface, my vote today is to pass it out of committee, but I just want to, you've heard great feedback, and this committee is pretty representative of the fuller board in terms of perspective. So the questions that you hear today are just going to be amplified at the board itself. And I agree with Member Longacre. When this committee speaks with a unified voice, I think that the board heeds it more, but I understand what you've expressed today, and that's certainly your prerogative. But in this time frame, I would just urge you to please follow with members of this committee, follow with members of the full board, and certainly staff, and make sure that their concerns are fully addressed by the time you come back to the full board in a month. So with that, the motion before the committee is that the committee approve Alcott Learning to be an approved educator preparation program and recommend approval by the board. All those in favor? Well, because I know it's not going to be a unanimous vote, let's do roll call. Let's start. Board Member Lear?
No.
Board Member Hall? Board Member Longacre? And Vice Chair Bollinger? Okay, and then I vote yes. So that motion fails 4-1. Thank you for coming in. Hey, committee, we'll take a 5-minute break, but I just want to remind everyone we have made some progress today, but we have about a page and a half of rules. So after 5 minutes, let's come back and, again, ask all the questions you need to, but let's keep our eye on the clock. Thank you. that is going to be made by the committee relating to the 2.4 matter. We're ready for a motion on the 2.4 matter, which is the Alcott Learning EPP application. Member Longacre, is that your motion? Sure.
Okay, I say that the committee continue this item to its September committee meeting and invite the applicants to revise its application in the light of the concerns discussed.
So the motion before the committee is that the committee continue this item, again, 2.4, to its September committee meeting and invite the applicant to revise its application in light of the concerns discussed. All those in favor? Board Member Lear? Yeah. That's true. So that passes 4-0. And again, Member Lear is being shown online, but we didn't hear her particular vote. So let's go to item 2.5, R277-330, Utah Effective Educator Standards. And Director Rasmussen, you'll be queuing this up for the committee.
Yeah, if we can invite Dr. Kellis up. They've had a committee working on the effective administrator standards to revise these. R277-330 contains the writing committee's recommendations for updating those standards. Those are found beginning at line 155 in the rule. And then I would defer to Quinn to discuss the other steps they've taken.
Dr. Kellis, please introduce yourself and we'll go from there.
Thank you, Chair and members of the committee. My name is Quinn Kellis. I am the School Leadership Coordinator. And we have had a fantastic past 10 months working on this, and I'm thrilled to be able to bring it to you for your review. I do want to give some quick introductions to some members of my committee. Well, that committee, it's not mine. We have Andrea Rohr from the Utah Educational Policy Center, Shauna Warnick, who is a school board member from the Nebo School District and is representing the State School Boards Association, Marilyn Taft from Weaver State University, and Amy Warren from PTA. Our committee had many others representing school administrators, students, teachers, and everybody brought their insight, which was very welcomed. The standards that you have are on display here represent that work. I will share that just a little bit of history. The original standards that are currently in place were drafted back in about 2011. They were reviewed in 2018 and determined to essentially stay as is. In 2023, there was a committee. However, that was so close to the end of COVID that the 2018 standards really didn't have a chance to take effect or be put into practice. And so they were deferred again. And so here in 2026, we are looking at the draft revision, which would be the first substantive revision since 2011. The committee looked at really two questions. What should school leaders do and what do they do? And that drove a lot of the conversation. Sometimes what they should do doesn't find a place in what they do on a daily basis because the fires that they put out in all their daily tasks consume their time. But these standards really are intended to be what they should do, but also be informative of what they do on a daily basis. As we look at the different standards, you can see that they, as much as we tried not to, just have a list of all the things. They are generalized statements. The intent is that the next steps will be more detailed work, which would include competencies, professional learning, toolkits, everything that would really get into the weeds of school leadership. But these standards would be the overarching statements that drive the role of a school leader. I don't know if you can pull up the backup material for this. We have a single document that has multiple attachments to it. Here is the committee. If you could just go right back up a little bit to there, you can see the various representatives. I did black out the student names for student privacy, but we appreciated everybody that was here on the committee. Scrolling farther, this first page was what was presented to the public for public input. This was our first draft. Based on public input, you can see this is the red line version that shows all the changes that were made as a result of public feedback. And then the next page is the cleaned up version that is presented for you for approval in the form of R277-330. Also included here is a fairly lengthy chart of every comment that was presented or submitted to the committee and what action the committee took. So there were over 200 comments that were provided or suggestions. Some of them, as you can see on the far right, it says no action. That was if somebody said, these look great. Well, there's no action needed on that comment. Others where there was opportunity to make a revision to the draft standards, those are noted in here. So every single input that was received was reviewed by the committee and is listed here for your information. If you go all the way down to about the bottom of this document, you will see our process, and that just shows you on a regular basis the month-to-month process that the committee followed. So with that, I'm happy to answer any questions.
I'll turn the time over to staff. I just want to say, not staff, to the committee, just to say, and I know we shared this before, but I just want to say thank you. The detail, the attention to detail, and the providing the effort that went into this, like to look at every comment, and not only to say that we looked at it, but to demonstrate to the committee and the board, this is what we did with that. I think that is a above and beyond metric. So I want to thank you for that. With that, are there any questions from the committee? And so I'll give the committee a few. Board Member Lear, I can't tell if you're looking for the hand to raise or.
No, I'm good. Thank you. I was just, I got my other screen, so
Okay.
I'm good.
Thank you. Vice Chair Bollinger.
Thank you, Chair. I want to echo what our chair has said here. This is a lot of work. I was really impressed with responses to all 200 comments. It shows that you really listened to the feedback from the community and really considered it. Educational leadership is an area that I think we definitely need an improvement on in the state of Utah. I remember going through the licensure program and I had to have 500 hours of experience, and with the competencies, it kind of went down to like maybe 50, or I mean, some programs have 200 or more, but it shows in the leaders that are coming out. And so I feel like this is going to help raise the bar where we're getting more clear, to your point, Quinn, on making sure we are training them on what they should be doing. And yes, there's plenty of other duties as assigned or things that are in the fine print as an administrator that you never thought you'd be doing. However, I love that this refocuses more on the visionary, more on the instructional leadership, and not just on the management piece. So thank you for the work to the committee and to all of those involved. I did want to just point out one piece in this rule. If we could go to line 161. I really appreciate in this rule how intentional this has been placed. So on line 161, it says to elevate student success, promote educator quality and effectiveness, and optimize oversight and accountability, Utah educational leaders apply the following standards. That's our strategic plan, goals. So not only was this great work, but it also supports the goals of this board and our hopes. So just a big shout out on this piece and on the work. So thank you.
Thank you.
Not seeing any hands, I think we're ready for a motion on this matter. Thank you, Board Member Hall. And I think, Director Rasmussen, who's calling up the motion on this matter? And it's 2.6.
All right.
2.5.
Want to make the motion that the committee approve R277-330, Utah Effective Educator Standards Draft 1 on first reading and forward to the board for approval on second final reading.
So the motion before the committee is that the committee approves R277-330, Utah Effective Educator Standards Draft 1 on first reading and forward to the board for approval on second and final reading. All those in favor?
Aye.
That passes unanimously. And the next matter, I think it's also a Dr. Kellis. This is a 2.6 R277-305, School Leadership License, Areas of Concentration, and Programs. Director Rasmussen, do you want to cue us up?
So this follows up on the committee's work in R277-330, and we've got a couple other changes to this rule. First, we removed the oversight category, also a recommendation to delete language on the required a school leadership assessment. And then you'll see that a lot of language has just been taken out of this rule. That was different competencies that were required in school leadership preparation programs. The proposed change would be that staff would prepare new school leadership competencies based on the effective administrator standards that you've just recommended that we adopt. So that would be the proposed changes in R277-305.
Thank you. I do have one question. When I reviewed the rule, it looks like we are eliminating the competencies that we currently have because those will be replaced. Is that correct? And do we typically remove the existing ones before the upcoming ones are in place? Is that how we typically approach that?
In this case, the recommendation is that the new competencies will not be board adopted competencies. So this is removing the old ones and delegating that particular responsibility to the superintendent. And so staff will work on those in conjunction with the new standards, but they wouldn't be board adopted, and that's why we're taking these out.
Okay, thank you. And in terms of that removal, would these be the only set of competencies in the education verse that the board doesn't review and approve, or is that we're just moving in that direction
Dr. Haidt or
generally?
Dr. Kellis might be able to speak to that.
Dr. Haidt?
Yes, thank you, Chair. Malia Haidt, Executive Coordinator of Educator Licensing. We have approximately 200 sets of competencies that are not approved by the board at this point for license areas and endorsements.
Any questions from the committee? Not seeing any questions, we're ready for a motion. Board Member Hall?
All right. Make the motion that the committee approve R277-305, Schools Leadership License Areas of Concentration and Programs Draft 1 on first reading and forward to the board for approval on second and final reading.
The motion before the committee is that the committee approves R277-305, School Leadership License Areas of Concentration and Programs Draft 1 on first reading and forward to the board for approval on second and final reading. All those in favor?
Aye.
That passes unanimously. Dr. Kellis, thank you. So the next item is 2.7 R277-106, Utah Professional Practices Advisory Commission appointment. And Director Rasmussen?
Yeah, so this rolls up for its 5-year.
May nominate community members to serve on UPAC. And historically, have we assigned or identified that state organization?
As long as I've been with the board, that's been understood to be the PTA. I don't know if it's ever been different. Member Lear might be able to speak to that when she was over UPAC, but as long as I can remember, that's been understood to be the PTA.
And has any organization requested or asked to be identified as that organization outside of the PTA?
Not to my recollection, no.
And it's my understanding that the two members that serve on UPAC have always come from the PTA.
In the time I've been here, they've all been nominated by the state PTA, yes.
So my question is, it says that the state organization or a local chapter of the education organization. Have we ever had applicants come from the local chapter of the PTA?
This last year we had one. That was the first time I can remember that.
And when these individuals, do they make the appointment or they just nominate individuals to serve on UPAC?
The superintendent appoints all members of UPAC, so they just nominate.
And the PTA nominees and the local chapter nominees, they both follow the same process?
Yeah, they just have to get a signature from an officer of their organization.
Okay, thank you. I just didn't quite understand that process, so thank you. Any other questions from the committee on R277-106? It's just up on its 5-year renewal. I don't believe there are any staff recommended
No changes recommended at this time.
I just see individuals reviewing it, so I don't want to rush, but not seeing any lights. We're ready for a motion on this matter. Board Member Hall.
Make the motion that the committee continue R277-106, Utah Professional Practices Advisory Commission appointment, and forward to the board for continuation on second and final reading.
So the motion before the committee is that the committee approve R277-106, Utah Professional Practices Advisory Commission appointment, and forward to the board for continuation on second and final reading. All those in favor?
Yes.
Okay, that passes unanimously. The next matter on the agenda is 2.8 R277-116, audit procedure, and I have Deputy Newey as queuing that up for the committee.
Thank you, Chair. So 116 is our audit procedure rule. It is also up for its 5-year continuation. Ran this by our audit team, and it also includes some things having to do with finance. So ran it by our finance team, and they have no changes to suggested this time. So it's just a straight continuation. Oh, there is, sorry, my apologies. We needed to hit the return button. So there is one small change right there on line 36. But other than that, no changes.
So with that, I see some board members reviewing the rule. Not seeing any. Yep. Not seeing any lights. We are ready for a motion. Board Member Hall.
Make the motion that the committee continue and approve R277-116, audit procedure, draft 1, and forward to the board for continuation on second and final reading.
Okay, the motion before the committee is that the committee continue and approve R277-116, audit procedure, draft 1, and forward to the board for continuation and approval on second and final reading. All those in favor?
Yes.
That passes unanimously. Thank you. 2.9 R277-323, public educator evaluation, comes to us by amendment, and Director Rasmussen.
Thank you, Chair. So this is a follow-up to a legislative change primarily. We have removed the oversight category, but the other substantive change that staff is recommending is if you look beginning on line 79, we've recommended striking a large chunk of language. That was all right, straight out of statute. The statute was amended, and staff is just recommending that we just update the statutory reference, which is now changed to the language has changed a little bit, and then we wouldn't have to we shouldn't be repeating the whole statute in rule anyway. So that's the recommendation for 323.
Okay, I'll just give the committee time to review those changes beginning on line. It appears to be
79.
79. And Member Hall has his light on. Are you going to make the motion? Okay. Not seeing any lights. Member Hall?
Make the motion that the committee approve R277-323, Public Educator Evaluation, Draft 1, on first reading and forward to the board for approval on second final reading.
So the motion before the committee is that the committee approve R277-323, Public Educator Evaluation, Draft 1, on first reading and forward to the board for approval on second and final reading. All those in favor?
Yes.
That passes unanimously. Thank you. The next item for the committee is 2.10, R277-324, Paraeducator Programs, Assignments, and Qualifications. This comes to us by continuation. Director Rasmussen.
Yeah, this is just up for its 5-year review. Staff isn't recommending any changes, just asking for continuation for the rule.
Again, and I'm giving the committee just a few extra minutes on each rule just because we met extremely late last night, and I just want to make sure that we take that extra time. I know that there's several committee members, even after we go home following committee meeting, we use that time to prepare for Friday. And to the extent that that time was abbreviated, I just want to make sure that the committee has one last opportunity to review these rules before voting. So we'll give it just a little bit more time. Not seeing any lights. Board Member Hall, is your light on to make a motion?
Make the motion that the committee continue R277-324, Paraprofessional, Paraeducator Program, Assignments, and Qualifications, and forward to the board for approval.
So the motion before the committee is that the committee continue R277-324, Paraprofessional, Paraeducator Programs, Assignments, and Qualifications, and forward to the board for approval. All those in favor?
Aye.
That passes unanimously. Thank you. Item 2.11, approval of para pathways. Director Rasmussen.
So one of the pieces in that rule is that the board approves the assessments, some assessments, and there is one of the assessments that the board has previously approved has changed in format, and so that's being brought back to the committee for consideration and approval. If you have any questions about the changes to this assessment, Max Lang is here to answer your questions about that. Max, if you want to come up. But the recommendation from staff is that the committee approve the updated assessment and the recommended cut scores for passing that assessment.
Good morning. If you just would state your name and position.
My name is Max Lang, and I am the board's coordinator of ESEA programs and related state initiatives.
Thank you. And I do see a light from Vice Chair Bollinger. So, Vice Chair.
Thank you, Chair. Max, thanks for being here today. I just wanted to, I've asked this question myself, but I think it'd be an important question for the public to understand and know. My understanding, and correct any errors that I make. My understanding is for paraeducators, there's 3 different options for assessment to take to be highly qualified. This is one of those. Is that correct?
Correct.
Okay, and then the other thing that I wanted to point out, so right now there's the Parapro. What this evaluation does, or this assessment does, is it provides a subtest for reading and writing separate mathematics. So if an individual fails one portion of that in the full test, instead of having to take the whole test over, they can just take the portion that they didn't pass. Is that correct?
That's correct.
Yeah. So I love this change. I love the opportunity. I know our para educators, right, they're having to pay for the tests when they take them. So it's nice that they save both time and money with this pathway. So I appreciate the updates that they have made here. So thank you.
Just one follow-up question to that. All three options still remain available. Is that correct?
That's correct.
Any other questions from the committee? Not seeing any, we are ready for a motion. Thank you, Member Hall.
Make the motion that the committee approve the Para Pathways Assessment from ETS for qualification of paraprofessionals and adopt ETS recommended passing scores for reading and writing and mathematics and forward to the board for approval.
Okay, the motion before the committee is that the committee approve the Para Pathways Assessment from ETS for qualification of paraprofessionals and adopt ETS's recommended passing scores for reading and writing and mathematics and forward to the board for approval. All those in favor?
Yes.
Okay, that passes unanimously. Thank you. So the next item is item 2.12, and I think just given the time and the matters that we still have pending before us, including 2.15, I would recommend, but the committee is certainly not bound by this, but the board yesterday referred a companion matter on data privacy to our September committee meeting. And if appropriate, I would welcome a motion to move this matter or carry this matter to our September committee meeting, just given the time constraints that we're under.
Chair, I'm happy to make that motion if appropriate.
Thank you, Vice Chair.
All right, I'd like to make a motion that the committee move this item to the September Law and Licensing Committee meeting.
It's really member Law and Licensing, but
she had a late night too.
Yes. So the motion before the committee is that the committee move this item, and specifically we're referring to item 2.12 R277-487, this item to the September Law and Licensing Committee meeting. All those in favor? Aye.
Yes.
Okay, that passes unanimously. Thank you, Vice Chair. Moving on, we are on item 2.13 R277608, Emergency Safety Interventions and Prohibition of Corporal Punishment. And it says Greg Connell is going to cue that up for us. I don't see him, so thank you, Deputy Newey.
Thank you. Policy Analyst Connell is in finance right now, so I'll take this one. R277608 is coming to you for legislative required changes. This has been a bill that this committee has worked on for quite some time from Senator Escamilla. She had passed a bill in 2025 that required some standards and data requirements for the use of emergency safety interventions and seclusion rooms. We worked through those last year, and then in the 2026 session, she added some additional changes, primarily in the area of the actual space in which the seclusion room is built. So what does that look like? What does the door look like? What does the audio and the visual equipment look like, and things like that? And so I want to give a shout out to our staff who've worked collaboratively across the agency to make sure that this rule reflects all of those changes. You will see in draft 1 that there's quite a few changes. A few are just updates, like you'll see on line 53. We just want to be clear what LEA means. You'll see some definitions that come from statute. And then toward the bottom is where you'll really see the bulk of the changes. So I'll take you down there. Apologies. So starting on line 262, you'll see the physical standards for the seclusion room. A lot of this just references back to code because code was so specific. We wanted to make sure that that there was nothing lost in translation. 608 is the video and audio retention requirement. So we worked with our data governors team to ensure that that was aligned with all of that law. Starting on line 279 is the physical standards again and the compliance framework for that. I will also say, okay, so then on line 305, we also have the safety inspections. So those inspections, we've been working with our staff as well as, if you remember also in 2026 legislative session, the building code was moved out of our office and moved to DHRM. So we've been working with them as well to see what would this look like. So I just wanted you to know we're covering all of that. And then finally, at the very bottom, sets up a standard for when USBE would step in with any sort of corrective action. There is something unique about the ESI, the Emergency Safety Intervention, in that there is an LEA committee set up specifically to handle all of the ESI issues at the LEA, and it is their role at the local level to oversee and monitor any things that pop up, right? So any kind of compliance issues and things like that. So we are making it clear that it's only the state's job to step in if that ESI committee is not doing what it is legally bound to be doing. So that's when we will step in. Those are the major changes to the rule. We also have several specialists and directors here to answer questions if you have specific questions to the rule. And if you don't mind, Chair, I could invite them up now, or I will leave that to you. But
Please, if you want to invite them up, that'd be great, because I know I have several questions.
okay,
So
perfect.
thank
They're
you.
going to be your people.
Thank you. If you'd both just state your names and titles on the record, and then we'll have a discussion.
Hello, I am Ashley Lauer. I am a behavior specialist on the student services team.
Hi, I'm Chrisanne Lewis. I'm the student services coordinator.
Thank you. And I appreciate Deputy Newey's introduction, because every time this rule comes back, I think, what didn't we get right the last 4 times this was here? So I appreciate that grace that was extended to the committee, because, look, I think this is monumentally important, and it is necessary to get it right. And I see that a lot of this has to do with the physical changes to the seclusion area, but there are some things that I noticed that are structurally different, not only for this rule, but that could apply to almost every rule we do. So I'm just trying to get a better understanding of why those directives were made. If we start with line 143 and 144, the intervention, and I'm interpreting that to be the use of the seclusionary facility, is only used when there is an immediate danger to self or others. And I recall that we labored, and I think it was a companion rule when it came before us, we labored hours over what does that mean? And we went back and forth with immediate. Under this particular change, who assesses if there is that immediate danger to self or others?
That is a great question. And we do have a definition in the definition section of the rule of immediate danger. It's actually immediate danger and immediate and significant threat, because both of those terms have been used in code and rule. So we use those interchangeably. And that is something that happens at the school level in the situation that's happening. Is there an immediate danger based on that definition that would warrant the ability to use either a physical restraint or seclusion?
And where is that definition? Oh, I see it. Line 50. Immediate danger or immediate significant threat means the imminent risk of physical violence towards self or others, or other physical behaviors which are likely to cause imminent risk or substantial or serious bodily injury. So I understand that definition, but who's empowered to make that determination? Is it the teacher in the classroom? Is it the administrator? Is it the SRO? Who is empowered to make that determination?
That's a great question. Thank you. There's nothing in the code or the rule that specifies that. It is whoever is involved in that specific incident at that moment. So if the administrator is the lead in that moment, it could be an administrator. It could also be a teacher. Whoever it is, though, has to have that. They have to be trained. They have to have that comprehensive emergency interventions training, and they have to have the background in order to do that.
Thank you. And I know that one of my LEAs reached out and their concern was, okay, someone is demonstrating these behaviors. There's an immediate threat. We use the seclusionary room. They're no longer demonstrating that immediate threat, but the concern is if we remove them from this area, that there will be an escalation. What does this rule require in terms of they were an immediate threat, they're placed in a seclusionary area, the immediacy is they're not demonstrating those behaviors anymore? Is the school or the individual in the school empowered to make the determination they're going to have to stay here because we feel like if they are removed from this area, the threat is that that behavior will resume? Does that make sense?
Yes, I'm trying to look at, there's language for physical restraint and language for seclusion when it comes to release criteria. So there is criteria that is needs to be written into the LEA policy that would outline that a little bit more clearly. And then there's also, I'm just looking for the line specific to seclusion that talks about, the student coming out of that seclusion based on, right, as reasonably understood by that employee if they're no longer that immediate danger or immediate threat.
So there is some leeway and latitude that we're empowering the local teacher, the local administrators in terms of their ability to assess whether or not those behaviors that resulted in the use of the seclusionary area, if they would have to be visible continuously, or even if there was a gap, perhaps they still could be housed in the seclusion area. Does that make sense? Or do they have to be exhibiting these in real time in order for them to be in the seclusionary area?
Yes, so really quickly back to your last question, it is on line 214 through 216, where it talks about the minimum time necessary to ensure safety as reasonably understood by the school employee. And then to your second question, there is, in code and rule, it states that there must be a continual observation while a student is in a seclusion room or in seclusion.
Thank you. And 215 is the language I was looking for. Use the minimum time necessary to ensure safety as reasonably understood by the school employee. So we are empowering that individual to make that determination. Thank you. Mm-hmm. And just the final area, lines 345 to 356. Part of me likes lines 345 and 346 because it is a shall and not a may when it comes to this issue. And when you're secluding a student, I think that's important that we mandate certain things. It says the superintendent shall monitor LEA compliance with the physical standard requirements for seclusion rooms in a manner determined by the superintendent. Are there discussions internally now on how we plan to do that? Let me ask this, how many seclusion rooms do we have in the state?
Just as far as the seclusion rooms, I think Elise will take the other question, but as far as how many seclusion rooms, we actually, in in the SB 181, which is the legislation from 2026, that is information that we have not collected previously, but every LEA is required to submit that information to us by December 31st of this year.
And if they build a new seclusionary room, they have to tell you that as well. And if they close one, they have to tell you.
Correct.
So my concern is with 345 and 346, we now have to monitor each of these areas. And as of today, we don't know how many there are. Is that fair to say?
Yes.
Okay. Deputy Nui, do you have something to add to that?
I could just add really quickly, that's exactly why we left it in a manner determined by the superintendent, because once we know how many there are, then we can see what is our capacity. Is something that we can go in and actually look at? Will we need to, defer to DHRM, those kinds of things. So once we have better numbers and better data in December, then we'll be able to lay out a plan for that monitoring that will outline those details.
And was this another mandate that the state shall monitor, but no provision was made in terms of funding for?
Correct.
Okay, thank you. And then lines 353 through 354. Again, we're taking some of the discretion away from the superintendent because the law says the superintendent shall take corrective action. So this is not a may, but this is the legislature saying if an LEA is non-responsive after receiving a notice of non-compliance or has an ESI committee that has not created a plan or resolved the issues of non-compliance, that corrective action shall be taken. Is that the discretion of the superintendent has been removed by this?
That's actually not in legislation. So if this committee would rather that be a may, we had felt as staff that because there was that extra layer of monitoring and observation with that ESI local committee, that would have to rise to a pretty egregious level in order for us to get involved in the first place. So that's why we wrote the shall, but I can totally understand why a may would allow for more discretion. So either way is fine. It's not in statute.
I mean, I'm inclined to defer to staff, but I appreciate you pointing out that this is not required by code, but that the staff using its best judgment felt that this might be the appropriate language. So thank you. I have no further questions. Not seeing any other lights. Vice Chair Bollinger?
Thank you, Chair. I know that we have seen this a lot. I'm just glad it's not the LRBI manual, if I'm just being honest. Yeah, that might have to come now with this. I get that. But thank you for your work on this. Just a question. So just for the public's knowledge, the majority of these amendments were taken because of the code that we were talking about, SB 181, correct?
Yes, that's correct.
Besides the corrective action piece, is there any other thing that staff added or changed that wasn't in SB 181?
Yes, there were a couple of non-substantive changes, but if you look at, let me find it really quickly, I apologize. It is in the policy section, so it's section 3 of the rule. And it is, there's two pieces in that section. So starting on line 117, the mandate from code was that we receive a report from all LEAs by December 31st of this year on their current status of seclusion rooms as far as compliance, as well as if there's any new seclusion rooms they're building. Our understanding was that the intent was that we would always know what that status is and the rooms that are being used. So the language that requires them to report new seclusion rooms after that December 31st date, or to let us know when a seclusion room is no longer being used, that is not directly mandated in code, but we felt like that was something that was understood as, we should have an idea of what seclusion rooms are being used throughout the state. And then there's one other piece in that policy section, and that is lines 138 through 144. And this came as we were doing a presentation, and there were some questions that were coming around this idea of having an emergency safety intervention in an individualized education program. And we wanted to ensure that even if they were written into an IEP, that it was understood that they were still only to be used as an emergency safety intervention when there is an immediate danger. So we just added that to clarify that as well.
Thank you. Thank you for those clarifications. And then just to piggyback off of what Chair Carey had mentioned, he had asked if there was funding for the monitoring that's required. My question is because now there's a new requirement. We know that any new building has to meet the requirements being built new. We also know there are so many of these rooms that don't meet the requirements. So districts, if they continue to use these, or LEA schools, have to go back and retrofit. Is there funding allocated for that?
There is not. There was originally a grant program in the bill that was introduced, but because of funding and budget, that grant program is no longer in place. There was, because of that, some flexibility in the time frame that LEAs would have to retrofit their rooms. And also, I think another important thing to note is that no LEA is required to have a seclusion room, so that is also something that if they feel like that is something that they no longer are in need of, they would not need to continue that room. But to your question, there is not funding that has been allocated.
Yeah. So if they choose to continue to have it, they have to meet those requirements on their own dime, including adding the audio and the visual and the space, everything. But they could choose to just discontinue the use of those rooms.
Yes.
Okay, thank you.
Just let me just follow up with something that Vice Chair Bollinger said and then Member Lear. So even if there's not a current need for the room, almost impossible to predict the future as to whether or not a new transfer student would use that facility. So I guess I'm just asking for experience, but in the experience of yourselves or somebody on the committee, how many rooms are actually substituted out where it was a seclusion room and now we're just going to do something else with it? Because I would imagine that the cost to ramp up, shut down, then ramp up again, is this a situation where once we have it, we typically keep it and have to maintain it because you just don't know the need? I'd just be curious to have some insight on that, if possible.
Unfortunately, I don't think that we know. We don't have data on that. And one of the things that happens with schools is they may have, a self-contained behavior unit in a school that where they're using a seclusion room fairly regularly, and then there's no longer a need for that classroom in that school, or it's moved to a different campus, and so the school may not feel that they need the seclusion room at that time. We just don't know until we have the data come December. We just don't know how often those are retrofitted, used for a different purpose, and then maybe brought back to a seclusion room.
Thank you. Vice Chair and then Board Member Lear.
Yeah, Chair, I can just share from my own personal experience working in special education that typically the seclusion rooms that I've seen have been at those schools that have those behavior units is what people often refer it to, or at special schools. So there are some schools that are considered special schools for our most severe behavior students, as well as some of our the ones with the most severe needs in special education that maybe be nonverbal. And so this is a safe way to help de-escalate them. So typically at those locations you see these. So I imagine that they'll have to make that decision then on what outweighs, is it worth the funding to make sure you have that in case there is a student. To your point, it may not always have a student at that school that needs it, but then they have to make that decision on that investment. But it sounds like we have till 2032 for districts to be in compliance with those changes.
Yes, that's what we've proposed in the rule, unless this committee or the board would like to adjust that date.
Yeah, I appreciate that flexibility because it is a big cost to incur to change those, but I also want to make sure that districts are following the law. So thank you.
Thank you. Board Member Lear.
Thanks. This is maybe for Chris-Ann or one of the other experts. I know that seclusion rooms are used could be used for all students, not just students with IEPs. But IDEA provide guidance? I don't know, it's probably beyond guidance, directives about what seclusion can look like and what these rooms look like. Am I mistaken in that?
The information, the requirements that are in this rule and in state code are much more stringent than anything that is in IDEA. And there are more general requirements, but I think within our state, I think this is going to provide a little bit more guidance. There is guidance through case law. There is guidance, through IDEA that similar to what we have here, that it should only be used as a last resort. But again, these regulations are much more stringent, much more strict than what you will find in IDEA.
Okay, thanks. And then just to kind of follow up on that, just so I understand, do other states have, is it typical for states to write their own requirements for these rooms? Or do they usually rely just what's in IDEA, though it just applies to students with disabilities? Or what's the general practice in this area? Could you tell me that?
Yes, so we did do an extensive search of other states and the rules and the regulations that other states have related to seclusion and emergency safety interventions in general. And not every state has regulations, but it's not uncommon for them to have regulations like this, whether they are very similar, less stringent, more stringent, but we did find quite a few states that had them.
Okay, thanks. That's helpful.
Not seeing any other lights, we're ready for a motion.
One quick addition, I apologize, Chair. We had one motion that we caught after the backup deadline that just needs to be clarified. And if there is a member of the committee that would be willing to do that, it's that we remove personnel and family from line 138 and that emergency safety be added to line 143 before intervention to clarify that it's still an ESI.
I can do that.
Thank you.
All right. Go ahead and make the motion that the committee remove personnel and family from line 138 and that emergency safety be added to line 143 before intervention.
So just let me, if we call up line 138, if we remove personnel and family, it would say school, and the IEP team. I just want to make sure that we're editing that correctly. And then 143, if we add emergency safety before intervention, the emergency safety, emergency, yeah, 143 works, but just double check the 138. So that would read school and the IEP team?
Just the IEP.
Is that unless, I guess it should say unless the school and IEP team have documented less restrictive means have been attempted? Please.
Yes, of course. I think we can remove school as well. So it would just be the IEP team have documented less restrictive means have been attempted.
Which should be the IEP team has documented. You can just make that non-substantive change.
Please. Yes, so I think, and the reason for that change is that the school personnel and family are a part of that IEP team. So that IEP team is inclusive of those other individuals as well.
Okay, that seems to make sense. So, Member Hall, do you want to revise your motion?
Make the motion that the committee remove school personnel, the family, and from line 138, or excuse me, from line 138, and change have to has on line 138, and that emergency safety be added to line 143 before intervention.
So the motion before the committee is that the committee remove school personnel, the family, and from line 138, and change have to has on line 138, and that emergency safety be added to line 143 before intervention. All those in favor?
Aye.
That passes unanimously. And not seeing any lights, we are ready for a motion on the underlying matter. Please, Member Hall.
All right. Make the motion that the committee approve R277-608, Emergency Safety Interventions and Prohibition of Corporal Punishment, Draft 1, as amended on first reading and forward to the board for approval on second final reading.
So the motion before the committee is that the committee approve R277-608, Emergency Safety Interventions and Prohibition of Corporal Punishment, Draft 1, as amended on first reading and forward to the board for approval on second and final reading. All those in favor?
Yes.
That passes unanimously. Thank you very much. Okay, we have two matters left, and I've asked Chief Audit Executive Davis if she could just give us a condensed summary of item 2.14, Audit Committee Statutory Change Requests. And just by way of background, it's my understanding that the Audit Committee has reviewed these items. They have recommended them to the full board, but the process is, or their recommendation is, that it go through a full committee. That committee is Law and Licensing. And so, Member Davis, if you could just explain those three matters to us, and we'll go from there.
Yes, absolutely. Thanks for having me, Chief Audit Executive Debbie Davis. As was mentioned, these three items are coming to you from the Audit Committee, so they were reviewed and discussed there. And then for additional transparency to the public, as we know that's incredibly important, they come to a standing committee, and then these are also included as part of agenda item 10.2 in the board meeting agenda. So there are the three items. These are things that are identified as we do work with hotlines and see things that come there. As we do audits, we identify risks. And so these were three areas where there's potential risk exposure. And so as directed by the Audit Committee, we prepared the forms. Those forms are available. You can look at them. You can see the titles there. The first is trespass from school properties. LEAs do have the ability, a school officer can trespass an individual. The cases we saw were parents were trespassed from school property. There are just not a lot of parameters around that. So the suggestion is, should there be some parameters, and that would be up to a policymaker to consider that. The other two, there's one about sex offenders and school-sponsored activities. The board is aware of this. You've considered rulemaking on this. This presents a couple of options potentially in code that could be changed. So there's a lot of different options there, just particularly when there's a school-sponsored activity that's not on school property. There's a little bit of a gap that's been identified there. So that's the kind of the consideration with that one.
C.A. Davis, were you here for the public comment on that was made? Was his public comment directed towards this?
Yes.
Okay. I wasn't sure at first, but now I understand.
Yes.
Okay. Thank you.
Correct. And then the third item is about LEA internal audit functions. If an LEA has 10,000 or more students, they're required to have an internal audit function. We looked at the code surrounding that internal audit function, and it's very high level and very brief. So this suggests that for the 14 LEAs, so we're talking bigger districts where this actually applies, it might be helpful in the LEA Internal Audit Act, if you will, to have some of the same detail that's included in the Utah Internal Audit Act that your internal audit department follows, just so that there's additional information for LEA board members, LEA administrations. We think it might be helpful for them to have some information. This one is scalable. There's a lot you can do, or there's just a little tiny bit you could do. So those are the three, Chair.
Thank you. And it's my understanding that you're not asking the committee to take particular action other than recommend that staff work with legislators on potential amendments to the Utah Code. Is that understanding correct?
So you can make whatever motion you would like to make at this time. We do have this in item 10.2, and it will remain there for until the legislative session starts. So at any time, a board member during that item can direct staff. Right now, they are already drafted and ready to go. And so as soon as the board votes to direct us to work with legislators, we will then take that and start looking for legislators who can champion this idea.
So this matter is already going to appear on the board
Yeah,
agenda
so you don't need to
regardless
take
of
any-
our action?
Yeah.
Okay. Vice Chair Bollinger, I see your light.
Yeah, thank you. I'd just, if I may, ask a clarification on the one for the audit committee statute change requests under the suggested legislative solution. So on the third one where it says 53G-7-402, paren 3, paren B, remove the option to contract for internal audit services. So is this change only impacting 14 large districts and basically saying you can no longer contract your audit services out? You have to have an internal audit person role.
Yeah. So yes, overall, this impacts. There are only 14 districts. Not all 14 districts do have contracted, so it will be fewer than the 14 that would be impacted. And I will say this, if you went the direction of saying like, yeah, we don't want to contract anymore, we actually want an internal audit function instead of making it an external, that would represent a change, and that's a more significant change than some of the other things that are suggested. But it would be limited, and this was actually a recommendation that an LEA board member made to me that indicated they were confused that why do you have an internal external audit? So that's where that came from.
And I guess the words that I may be getting caught up on are the remove the option.
Yes.
So are we then limiting districts and saying, hey, any of you schools that are smaller, you can do what you want, or districts are smaller, you can do what you want, but we're holding larger districts to a different standard? Can you help me understand why that would
absolutely.
be?
So smaller districts don't have an internal audit function at all, so this will not impact them. That's not it. So it's only larger districts that this applies to. So it's not like there's one standard for small and one standard for big. There's only, hey, large districts, you have to do this. That's it. So then you would be prescribing, hey, this is what internal audit looks like if you're a large district. But I guess you're right. Small districts can do whatever they want.
Right. So why, can you help me understand why the recommendation to limit the option? Because typically, I mean, we've had conversations yesterday where we've been so much about local control. So why would we want to say you have to do it inside and you can't contract out? If it's better for that local education association to make that choice, why are we asking that to be limited?
So, well, that's a great point. You're right. Local control is there. So I would say some of the pros of having an internal audit is that you actually have someone that has knowledge, like what I'm able to provide for this board because I'm working for you, like full-time job here. So I have additional knowledge. I can assess risk better for you than a contracted firm that will essentially come in and do 2 or 3 audits throughout a year because it gets expensive. So you essentially bring that knowledge base into your organization. But I will say I'm not aware of any of those smaller, less than 10,000 student LEAs that actually have an internal audit function. So while they do have the option to have a function, I'm not aware that any of them do. So I don't anticipate, again, that there would be any impact to them. But in principle, you are correct.
Yeah. Well, and so I'm just wondering, does this become an unfunded mandate? If we say you have to have your own internal, you can't contract out, and they have to hire somebody to be their own audit.
So currently, if they are contracting for the service, they're already paying. So the question is the pay for a contracted service equivalent to an FTE? So that's a legitimate question.
Right. Then we may be, if they found a way that's more effective and efficient to contract out, we're now limiting that ability.
In consideration of the services provided, the ability to risk assess the individual there. So if you consider all of that, I think that would go into the consideration of, the funding and if it is an unfunded mandate or if it would be equivalent or not.
Yeah, I struggle with this one a little bit for all of those reasons, but I appreciate that.
Like I said, you can take this out, do the other parts. It's scalable.
And Member Leader, I see that your hand is up. Is that for this matter?
Yes. Well, yes, I want to speak to this, but I also had a similar comment about the issue about trespass. So I can start with this. I tend to agree with Vice Chair Bollinger. I'm a little reluctant to, and I'm willing to discuss this with the full board. And it's probably, it'll be a good discussion. So I'm not necessarily going to vote no on these now, but I do think, as I'm looking at this more carefully now, that it's a little presumptuous of the board, this committee and then the board, to say you have to hire an employee that does this, when typically LEAs are very capable of deciding what kind of employees they want and what kind of contractors they want. So that especially in this era of losing funding every year for public education, I'm reluctant to tell a LEA you have to hire this employee. That involves benefits and a certain level of pay. So I do have reservations about that. I also had a question for Debbie, if that's okay. If there are any, if she knows, are there any LEAs? Are there any charter school? I know individual charter schools. I just am wondering if there are charter school entities that would be the same size as the bigger school districts. If Debbie knows that. That's maybe outside of her area of expertise, but maybe she does.
Please.
So last time I ran the data, the top 14 or the 14 that meet the criteria of 10,000 students or more were only districts. So a charter school was not that large yet. We probably have a couple that are getting closer, but none currently.
And are the charter schools, to just follow up briefly, thank you, the charter schools are evaluated, like, for instance, a conglomerate like APA would be evaluated school by school, not as the overall network of charter schools. Would that be accurate? Of its schools. Same with perhaps Summit Academy. Is that right, Debbie? Am I thinking?
The way we have looked at it, and I suppose it could be subject to interpretation by a legal mind, which is not me, is we use the data that's available through our data and statistics team to look at enrollment. And I believe, so APA, it's not a school enrollment. It would be for all of their campuses. So did that answer the question?
Yeah, and so it doesn't rise to 10,000, neither does Summit Academy, for instance.
Correct.
I just wasn't sure. And so I am sort of hesitant, not sort of, I'm hesitant about making this a board request to the legislature right now, because now as I'm looking at it, having had multiple financial discussions with other board members in board meeting about how we're going to have to be tightening our belts further, this is adding an employee to 14 LEAs. And again, leaving out 120-ish, 30-ish LEAs that maybe have similar issues and they don't have to do anything. And I think we maybe ought to reevaluate that.
So I want to thank Member Lear. And again, I want to thank, we have Chair Hall here. He chairs our audit committee. We have C.A. Davis. I really appreciate the willingness. It's a lot easier to say we're not going to go through a standing committee. We're just going to take it to the board. But I think we do miss out on some of the hard questions, the illuminating questions. So I want to thank both the chair and C.A. Davis for their willingness to, maybe we're not the lion's den, but it's certainly harder questions. So thank you for that. I am grateful for it. It's my understanding we don't need to take any action on this matter. Do we need to put something on the record that we're not taking action? Or can we simply move on and just state it verbally? It's already on the agenda for the full board, so.
And excuse me, Joe, but I did have one other, I wasn't sure if we were moving on or if there was action to be taken.
Oh.
But I just want to say, and I'll try and do this briefly, I have a similar concern about the issue of trespass on LEA campuses, because there are 160 of them. They're different sizes. They're in different kinds of areas. I'm not sure I want a legislative rule or a statute about that. I I was reaching for the discussion we had in the audit committee, and I appreciate that it would make our audit team's lives easier. But I'm also a great proponent of local control. So the more I've thought about this, I have the same reservation about the trespass issue as I do about the audit issue for different reasons. But I'm willing to let it stand and go to the board for further discussion.
So with that, as this matter is already listed on the board agenda, there's no reason for this committee to take action. So we won't take action. But there is, thank you, Sae Davis. There is one more item on the agenda. That's item 2.15, School Safety Dashboard. And it is noon, so that is our end time. I'm torn because I have spoken to Director Coda. Is there time if we don't take action, move this to the full board? Yes, but the preference would be that we do move it to the full board. But I just want to stress that everybody came up to the table. Wow, I was going to stress that this is an important matter and that we get it right, but I would ask for the indulgence of the committee that if we have pressing questions, we ask them, we put them on the record, but I would also ask that we be cognizant of the time as well. So with that, if we could just have everybody introduce themselves by stating their name and their position on the record, and then we'll just turn it over to the committee for questions. So Director Cote, if we could start with you, and if you want to introduce your team or have them do that themselves, your preference.
Hello.
Is it not working? There we go.
Thank you. Hello, I am Chantel Coda. I am the Director of School Safety and Student Services, and I will turn it over to Ashley Postello.
Good morning. My name is Ashley Postello. I'm the School Safety Center Specialist.
Hello, Rhett Larson, School Safety Center Coordinator.
Hi, I am Dr. Willie Chen. I am the School Safety Data Analyst.
Thank you. And this item, just for those listening, is item 2.15, School Safety Dashboard. I see that the committee is reviewing notes and the materials, and we will entertain questions whenever Vice Chair Bollinger.
Yeah, thank you. And I do want to preface with this with many of us have had an opportunity to hear a lot of this information in a small group setting. So I appreciate the time and energy that's been put into this. We've spent you guys have spent probably hundreds of hours. We've spent a few hours. Just for clarification on these, so there's some documentations for workbook groups for several different topics. Director Coda, can you just, for the public's knowledge, who was on the work group? Did that include just staff members from USBE? Was that comprehensive to a larger entity where LEAs involved, parents? Can you help us understand the scope or let the public understand the scope of the work groups?
Yes, I'm happy to. Chantel Coda, Director of School Safety and Student Services. This process was set up to really look at best practices across not only the nation, but really in our state. And so if you look at the workgroup agenda, there were several items that these work groups had to look through. And I'm describing the process first before I describe those involved, just to kind of bring us all together on the same page. But the groups that came together, they were asked to look at 4 specific items. They were asked to look at Utah Code 53E-3-516, the School Disciplinary and Law Enforcement Action Report, which is really where a lot of the legislation around this reporting came from. They were asked to look at the USBE strategic plan, any other code or statute that we're already collecting data on to that might better help understand and contextualize data for that law enforcement action report, and then any conversation on the best interest of public knowledge that might be helpful to parents, again, to contextualize. Anytime we're putting data out there, we want to make sure that schools are fairly and accurately represented, and in order to do that, sometimes you have to add multiple data points to really tell the full story of what's happening at the school. So with that, we pulled together USBE staff to lead these work groups. Now, the staff that led the work groups were primarily from the School Safety Center, and just as a reminder, too, the public, the School Safety Center is made up by USBE staff, but we also have liaisons from our partners. So the liaisons include the Department of Public Safety, the Department of Health and Human Services. We have a charter liaison, and I recognize that charters are part of who we are and what we do, but because there are different boards, we have a liaison as well that can represent the unique needs of charter schools as well, and that individual was represented. And then we have representation from Safe UT, who's also a partner to help us to recognize those needs as well. So that's the context of the groups. They were led by USBE School Safety Center staff members, and then members from our staff, including those liaisons, were dispersed throughout the group. So what we did is we pulled everyone together. We looked at the different areas at kind of a larger level through the School Safety Center. We identified these content work groups, and then we pulled together USBE staff and those liaisons. Now, as part of this process, staff was directed to reach out to any stakeholders that they felt might be appropriate or bring appropriate conversation to the context of this work. And different groups operated differently. Some reached out to folks that, like liaisons, for example, reached out to others in their organizations to get some additional information. Some reached out to schools and those that they may have worked with or have just a relationship with, and some relied on past data, so information that they've received maybe through past interactions or just working with schools or entities on matters that may not be directly related to the dashboard, but provided them with feedback in that way. Does that answer your question?
It does. Thank you. I just wanted to know how much vetting we got from local LEAs, because the LEAs in my area are panicked about this.
Yeah.
And that's why I'm asking, because I really, we just actually had a presentation yesterday from our reports and requirements about the amount of money and FTE it takes for reports and requirements. And as I'm looking through these, let me give you an example. So if I go to the recommendations of, let's see, which group was I in? Let me go to the one that's the student discipline and bullying. And again, I can tell there's been so much time and energy put into this. And we absolutely need to do what's required, right? I love how this one is specifically broken down into what's currently required and then what's not existing or not required. I really hesitate to add anything that's not required because of the load, the cost. I mean, there's so much that goes into this. The other thing that I wanted to point out on this specifically, and the feedback that I've gotten from the LEAs in my area specifically, I mean, I have pages of feedback from this because I said, hey, can you look at these requirements? Help me know, what are we already collecting? What's not a big deal? Because if it's something that they think is important and it's easy to collect, and I think that one of the things you said is if it's in the best interest of the public, right? Mm-hmm. But some of the concerns they brought up is a lot of these things, like the currently required, we go up to number, let's see. Yes, so it goes up to 6, and then this is the chronic absenteeism one, right? That you have up. Oh, is that oh, okay. So then we go to, okay, so we start with, so 6 are required, and then we go from 7 to a lot of requirement. So it was on page 9 or 8. So if we go to the student discipline and bullying recommendations, and then on the currently required starts on page 4 and goes up to number, let's see. Goes up to page 7. So there's 6 items that are required. We start on page 8 that says not existing or not required, and it goes from number 8 to 23. So that is a lot of points of information or data that we're trying to collect. And one of the things that the LEAs pointed out to me is, for example, on item number 7, it says, well, it's already collected in the SHARP survey or the school climate survey. However, not everybody's required to do those. So if you said these, we want to make sure there's fairly and accurately represented from districts. So if we're putting this on a dashboard and of all of our schools that are out there, but not everybody collects the data, how does that create a fair and accurate representation?
Can I speak to that?
Yeah, please.
Yeah, thank you. Those are great questions. And that is why these are recommendations. We wanted to bring kind of the array to the board, to you all, to talk these through exactly as you are. That is why if you look at it, says the following items would need a statute or rule change if you want these. And the idea behind that was just to, again, help the conversation around contextualizing the data. And so going back to the fair and accurate, I agree. If we're going to ask for something that's going to be public facing, it would need to be something that's required across the board. And so that's why these are recommendations. These are things to think about as you all as board members are making decisions. I think the primary goal that we as staff had in pulling these together was to help contextualize the data. So these were just points to help for your consideration as you're talking through, would this help to contextualize the data? So an example might be if I am a parent and I'm looking at a dashboard and I see a high number of incidents, that may cause me to think one way about the school, but then if I can look and see their policy and maybe some school climate data and see that, okay, well, wait a minute, there's more going on here than just a high number of incidents. That is the reason why these recommendations were put here. So please know they are just recommendations based off of the broader conversations that were had for you all to consider. So, feel free to cross some of these off or take the ones off that don't seem to make sense. Again, our goal was really just to really in the best interest of the schools to have as much data. If we're going to go public, let's put the information out there that's the most helpful to the public in a way that helps to tell the story rather than just specific data points. And so when we looked at just the required pieces of that law enforcement and disciplinary action report, it's pretty cut and dry. Right. And so arguably those are the things that are very specifically outlined. But if you look at some of the other dashboards in other states or other areas, there's a lot more information that parents have access to, even information that's more qualitative, like policies or, what is this, a blue ribbon school? Like, what is this school really all about? And so that's why you'll see recommendations on each of these for your consideration in terms of what could this look like. And also keep in mind, we're working with a contractor. So as the contractor moves forward and creates these skeletal prints of what the dashboard might look like, I think, we'll obviously bring that back to the board and you all can kind of look at that and see, because right now we're looking at a bunch of words on paper, but when it gets to the dashboard and it's more of a visual opportunity for people to see data, I think that might be more helpful as well.
Yeah, thank you. And if I may, Chair, follow up. See, my concern is, to your point, we want it to tell the story, but data out of context doesn't tell the story. So, for example, we were just talking about, seclusion rooms. Those schools that have maybe a behavior unit in the school are absolutely going to have a higher incident rate. But parents looking at that dashboard won't know that. And that's my concern with if we are not comparing apples to apples, right? We're comparing apples and oranges because that's not across the board. Then I think we're giving misinformation to schools or to parents. And if the purpose is for parents to make informed decisions, I think it's more important for the parent to go into the school and see what's happening than just look at a bunch of numbers and not really know what those mean out of context. Now, obviously, some of these that are required by law, those are going to be more consistent because they're required by everybody and a consistent way to measure it. The recommendations, several of these fall way outside of that scope, especially when when it's like and we do those districts that choose to give a SHARP survey or a climate survey, they absolutely use that within their LEA to make informed decisions of concerns, and those things need to be addressed. So I can see how some of that information could be helpful. But I'm concerned, especially given our time constraint, with what to be doing this. The other thing, and I had already asked this too, is has this gone through our reports and requirements committee?
This is not. The first direction was to bring it here so that we could have this broader conversation and see where you would like to direct this conversation to move forward as well.
Yeah, so Chair, I'd like to make a motion when it's appropriate, but I can hold off while you guys ask other questions.
No, that's fine. If you want to make a motion, that's fine. Technically, I guess we should have a motion on the floor, but as long as we have a chance to continue asking questions, or if you want to hold the motion, I'll give you priority. Thank you. Board Member Lear.
Thank you. And if you'll permit me just a moment of sort of catharsis, I have such frustration with this subject matter because for some of the same reasons that Vice Chair Bollinger just discussed. On the one hand, I want parents to know what's happening in schools. I absolutely want them to. On the other hand, it has to be in context and it has to come similarly from all schools or it's not accurate. It's not even I don't even know the best word to use. It's not fair. It's not it isn't accurate information. And then also it has to have a certain level of objectivity. So I'm always weighing parents deserve information about where their children spend many hours a day versus that information has to be accurate so that it fairly captures what's happening with the teachers and administrators and other employees as well as the students in that school. So I am not, and a dashboard is way different than information collected in our office to provide technical assistance. It's very much forward facing and it also has to be updated appropriately. So it's not without a significant amount of work that's even irrespective of the collection. So I just have huge reservations about this. And I'm wondering, and this is not calling for an answer, it's more of a rhetorical statement or question, if we maybe after the first of the year should revisit requiring the SHARP survey again, because at least those questions have been written by professionals and we get the same information from all LEAs. Granted, parents could still opt out, but we would at least have some objectivity and some comprehensive information. But without that, I am just concerned about putting this information out on a dashboard where many people draw their own conclusions without context. Like, as Amanda said, what kind of schools are in the district? What resources does the district have to work on school culture? Does the school district have a police department within the school district? What about their SRO? How does the SRO function? And so I just think there's so many qualifiers within this that I really have huge concerns. And I'm not criticizing staff at all. We ask you to collect this information and you did the best you could. Now I'm just trying to be responsible in how we use it. So I want to discuss it further, but I want to find something that is a fair representation of what happens in schools and is consistent so that parents are looking at something that is that fairly represents all of our 160 LEAs, not to mention the hundreds of schools that are represented. So thanks for allowing me to have that little moment of catharsis and express my concern about dashboards without really carefully considering the consequences.
Thank you, Board Member Lear. And before we recognize Vice Chair Bollinger for her motion, I just want to add that, and I know you're well aware of the risk because we talked about it on the School Safety Task Force. When you just put data points out there, it's misleading or could be misleading. Yesterday, we talked about perhaps on UPAC Matters listing a particular school or district, how many UPAC Matters they've had. And afterwards, Chair Hymas came over and he said, so Joe, what happens if you get a new principal and they show up and they decide, hey, you know what, we've got to clean up this place and there's a spike in UPAC Matters? Does that mean it's a bad school or does that mean it's a good school, right? I mean, to quote the Wizard of Oz, is it a good witch or a bad witch, right? You can't tell sometimes just by looking at a particular data point. So I'm grateful that in addition to the ones that the legislature said, the dashboard idea did not originate in this board, right? That's a legislative mandate, something that we are required to do. And they told us there's certain data points you have to include. I'm grateful that you, Director Coda, and your team have said, you know what, we need to make sure that we capture an accurate picture. Can you ever do that just through data? I doubt it. But it's something that we've been charged to do, we need to do, and I think we have to do it in the best way possible. So I appreciate the hundreds, if not thousands of hours which have gone into the development of what you put together. I'm grateful that you divvied out what's required, what's optional. And then the board has the difficult task of looking at this and saying, which data should we be using? But I just wanted to say thank you for that time. And with that, I will recognize Vice Chair Bollinger. I'll recognize Board Member Longacre.
Thanks. I just want to make a point. I'm so leery of using the SHARP survey as a data point. Just my own kid comes home from soccer practice. Mom, I'm being bullied. Oh, what happened? Oh, he was the butt of a joke. That's not bullying. And I'm afraid that we're going to use these results and it's going to hurt schools, and that's not an accurate picture. I would also want to use counselors' viewpoints. They really have an idea of what's going on in the school. Do we have a bullying problem? They'd probably know. Do we have whatever problem? They would probably know. So I hope that we use data points from a variety of resources. And when we put data on this dashboard, I hope that we send a message. Here's some information, but I hope this doesn't deter parents from going into the school, because you get a totally different feeling going into the school, seeing the ladies at the front office, meeting the principal and the teachers. So you may get one viewpoint from numbers, but there's a totally other viewpoint from face to face. So I hope we still encourage parents to go into schools and really get a better picture.
Thank you, Board Member Longacre. Vice Chair Bollinger.
Yeah, thank you. Again, I just want to say I recognize the amount of time and energy that's gone into this. It's very detailed. It's very thoughtful. I know that these extra recommendations are on here for some reason that maybe we weren't part of those discussions. So, I mean, if I were to pass this today, I would say only pass the ones that are required. But there may be some in the recommended, even from the feedback I got from LEAs, that might be worth considering. But I believe that we need to give it the time and space to have those deeper discussions. And I know that the thought was to come through us, and I do appreciate, and we've learned so much, but I also want to look at requirements as a whole and the impact that it has on LEAs. And so that's the reason why I'm gonna make this motion. And I also don't want to stall it, and because sometimes when we stall it, it dies. And so it's like, you don't want to do all this work and then have it go nowhere. And then all of a sudden we are only doing the required work, right? Because that's what would probably happen if we didn't do something with it. So with that, I'm going to make a motion that the committee send this item to the next Administration and Transparency Task Force meeting on September 16th for review and discussion, and to send their recommendations to the full board. So then they can kind of look at that holistically with all the other requirements. They're the ones that have been looking at tracking data, and then they can bring that to the full board.
Thank you. We have a motion on the table. Let me ask, is there a time constraint if we adopt this motion? Are we putting the dashboard and the requirements that we are under by law, do we jeopardize those? Do we put them at risk? No impact? Please, Director Coda.
Thank you. Yes, happy to answer that. I think I can answer that question by just kind of taking us back to where this originated from. So This goes all the way back to the parent portal. So the sponsor of the parent portal was the intention of that was that it would be more of a dashboard. And as you've been onto our site, we've seen it's more of a static web page. So if we look at it through that lens, the ask from the sponsors of the bill has really been to have some sort of a dashboard for several years now. Now, we did come back to the board, back to the table rather, and talked a little bit more about, what the actual ask is. And that's when the sponsor of the bill then added the additional line under the parent portal code to create that comparative data, to add the school disciplinary and law enforcement action report data in the parent portal, and to have the parent portal function more as a dashboard than necessarily a web page. So then from there, we had some conversations around the data points. We pulled together our amazing staff here in data and statistics, and we struggle with that for a little bit here because of privacy and some other concerns. And so what we did is we published that report in just a PDF, just to satisfy, hey, we're getting the information out there. We know it's not in a dashboard or comparative form necessarily, but it's in a PDF, and the public has access to that, and you all as well. So in this last legislative session and speaking with the policy makers, we talked about, just where we are, why we are where we are, and the desire to meet law and to fulfill this law from the policymakers. And so with that, we had the conversation, and we were able to extend the date to July 1st of 2028. When I say date, that's like live and running and out there, and the public is working with that. So I know that's a long answer to your question, Member Carey, and I apologize for the length of that, but I think it's important just to look at it in context of how this originated and then what it looks like to get it fully done. So what that would look like is we're in contract right now with our partner Safe School for Alex, who will help us to design and add any points that you all as board members want to put on. And then they'll need, once the decision is made in terms of the content and the look, they'll need several months to put this together, to beta test, to do all the things that are above my pay grade in technology that I probably couldn't even speak to, but they'll need a lot of time to work through that as well. So I want you to have the time to get this right and to get the right points on. But there's like two tracks on the train here. We've got that piece of it, and then we've got the other side of the developers wanting to make sure that they can jump over their hurdles. So content's one big hurdle, but then we've got privacy, and then we've got just the technical, like what button goes where, and do we make it pink or red or blue, and then how often do we upload the data? So there are several decisions that need to be made, and so the sooner we can come to a consensus to at least get the developers working on the material, the better positioned we are to meet that deadline, that revised deadline. But of course, I respect that you want to get input from any others. So it is going to, the more steps we take, the longer it will be, just because it's a process. So I would just take that into consideration.
So, Amanda, is your light on because you have
Yeah.
okay.
Yeah, I just wanted to.
Vice Chair Bollinger.
Yeah, I appreciate that. I'm wondering then, with that additional information, if I need to amend my motion so we could move the required pieces to the full board and then send the additional recommendations to the task force. I think that would help our developers move forward with those that we absolutely know we have to do, but then allow us some additional time to make considerations for the additional pieces. That might be the best way to move forward. Okay.
It looks like there was, I'm going to interpret as nodding of the head that was acceptable. So I tend to agree with that again, just because it is it's a monumental step. I know that the task force is looking at reducing the burdens to LEAs, but I'm going to oppose this motion, although I agree with it in concept, just because I just don't want to remove our seat from the table. The legislature has already granted one extension. I think they've allocated funding for the building of the interactive site as well. So I don't want to send the message that we don't understand what they're asking us to do. We've done that before, and we have found ourselves no longer invited to participate. And I just want to make sure that we don't send a similar message here. So I appreciate the division. I think that's a positive. But again, I'm going to oppose it just because I fear that we may risk our place at the table with a vote like that. So thank you. Member Hall, your light is on.
Do we need to include something in this motion that would make sure that this comes back to the committee when it's go through this process, the review process?
It's going to the board.
It's going to the full board.
Yeah,
after
we
that?
we could ask and if we want to have the transparency or the task force send their recommendations back to us, we could. The reason why I chose the full board is just to save time.
Sure.
But absolutely, if you would rather have it come back to the committee, I'm not opposed to that.
That's a whole nother step. I didn't know if that's what you were getting after, Joe.
No, the way I understand it is that we're going to vote, and if it's required by statute, those elements are going to go to the full board in September. All the other recommendations would be going to the Administration and Transparency Task Force.
Right.
And I appreciate that change. I'm going to oppose it, but I appreciate the change. Okay. So with that, there is a motion on the table. That motion has already been stated. So the motion before the committee is that the committee move forward all legally required data elements to the full board and send all recommended data elements to the next Administration and Transparency Task Force meeting, September 16th, for review and discussion, and to send their recommendations to the full board. Any discussion? Not seeing any lights, we're ready for a vote. All those in, well, since it won't be unanimous, let me just take roll call. Member Lear? Oh, you're muted.
Call on me last, please.
Okay. So let me start with the maker of the motion. Thank you. Member Longacre? Member Hall? Member Lear?
Well, that was great because I heard none of those votes.
Oh, because all the...
That was perfect for you.
So Member Hall, Member Longacre, and Vice Chair Bollinger were all yeses.
And I'm also a yes.
Okay, and I'm going to oppose the motion. That motion passes 4-1. Chair Carey in opposition. Okay, with that, I think that was our last motion, last matter, so we can entertain one more motion. Second? Oh, no seconds necessary. Granted, we're done. Thank you.